You are unmuted.
Welcome back, guys. It looks like, boy, what timing. They are already coming back into the courtroom. We have another note. It's probably going to be
22117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
The jury is at an impasse. I'm disappointed. I was really hoping the Tuey-Rodriguez instruction would get them there. Oops. Pardon me here. I got too many screens going at once. Yeah, I was kind of hoping if they didn't come back before lunch, they might be able to sort out at least some of the charges.
Close the session, please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
Now that one definitely makes it sound like somebody on this jury is legally educated. The comment about having to compromise their deeply held beliefs, that's getting awfully close to legal speak.
Thank you. Be seated. Court still in session.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
That's fine.
I'll just look at my calendar. Could we do the 22nd at 2 p.m., Your Honor? And I would hear from my client.
Is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to be for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates, so.
What about the 19th and 9th? Is that whole week?
No, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 8th, 9th? Any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so for those, Ms. Little and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
Proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Little and I probably will not.
Okay. So you and your client will be here in person, Ms. Giannetti.
Okay.
All right. All right. Thank you. We'll see you then.
All rise.
Well, that is very disappointing. Very disappointing. So another very well written note. If not a legal professional, at least somebody who is, very, very articulate and has really parsed into these jury instructions and the language that's in those. And from my reading has kind of drawn on that to have their communications with the judge. Well, so they'll come back on July 22nd, just Mr. Yannetti and Ms. Reed. And at that point, that's when we can expect the Commonwealth is going to ask for a new trial date if they intend to go forward. My prediction is almost certainly they will ask for a new trial date, just if nothing else to have the option open in case they change their mind later. But can't rule out that they would decide to walk away. But quite frankly, if what they had already received in this case going into the trial wasn't enough to push them off the prosecution, I don't really think a hung jury is going to be a big impediment personally. That's definitely my read. But I guess we will just have to see. I'm going to leave the stream going in the background just in case something happens as far as jurors wanting to talk, be interviewed, something like that. I guess we'll see. Definitely seeing lots of questions already about are we ever going to know about the jury divide? And Michael, you are correct. They are not allowed to poll the hung jury. So what happens when Judge Bev says she's going back there in a few minutes to talk to them? There is an instruction that she'll give to them at the conclusion of a case. And it basically tells them that they are no longer under their obligation to refrain from discussing the case from anybody, but it's basically their decision whether they want to do so or not. I did see somebody had brought up in Massachusetts in particular, the jurors are instructed that they should avoid disclosing the names of any other jurors, the vote of any juror, or basically what was discussed in deliberations. So they're very strongly discouraged from getting into details much beyond their own role and their own participation. Now, is it a crime if they do that? I don't think so. But just as a matter of kind of respect for everybody else that's involved, that is the way their instruction reads. So it's very strongly discouraged for them to do that. Another question I have seen a lot of, how long do they have to bring her back to trial? So I did some research into this, and it looks like in Massachusetts, there's a rule that basically sets an outside limit, a deadline of about, let me find it here. It sets an outside limit of a year. And the reason why, in my perspective, I think it does that, here's the rule. I'll just go ahead and pull it up. The reason why it does that is because there's constitutional limits on a speedy trial as well. And the way that those rules work, it basically says that after a year delay in bringing somebody to trial, there's a presumption that that is prejudicial to the defendant. So any delay that is 1 year or less is not presumed to be like unconstitutionally, not speedy enough. So they set their limit basically just so they can skate right under the line, the limit of that constitutional speedy trial rule. So anyway, this is the rule that I'm looking at here. It's here in subsection B. Wait. Yes, yes, yes. It's here in this the second part here. If the retrial of the defendant is ordered, the trial shall commence within 1 year after the date of the action, occasioning the retrial becomes final. There are, possible ways that these deadlines can be extended because of, a variety of different factors, witness unavailability, other things coming up. They're just kind of all set out in the rule. So it's not a foregone conclusion that 1 year, automatically means 1 year. But at least in theory, that's kind of our default rule that that we're working with as far as what the outer limit deadline would be. Now, having said that, do I expect it to be a year from now? No. Although I will point out guys, I'm a silver lining kind of person. I just am. I think you have to be, maybe in criminal defense. You just got to look for that silver lining. I do remember both sides here had originally wanted to continue this trial because of the ongoing FBI investigation. They had wanted time to be able to follow up on all the FBI materials and potentially wait for some type of resolution on the federal front. So to the extent there is a bright line, a silver lining here, it may be that this is now kind of giving space for that to happen. And that could potentially have an impact on, I'm not going to say the ability to go forward, because they have the power to go forward regardless of what the feds decide to do. But it could certainly affect their choice to go forward. The biggest implication that I think would come down from, should the feds have indictments, decide to proceed against anybody who may be a witness in the case, then the most obvious consequence of that is that witness will very likely plead the fifth in a future trial. And so then, depending on that witness is, who that witness is, that could affect the Commonwealth's desire to proceed with their case. Because, if, for example, hypothetically, your lead investigator is getting on the stand and implicating himself in criminal activity, that's not really going to be helpful to you in securing a prosecution. I do have some thoughts about possible things that just things that could happen in a retrial in light of what we saw come down the pike this time around. One of those, I would expect, certainly if I was the defense lawyer in this case, I would be looking very hard at bringing a motion to exclude Trooper Paul's opinion testimony on the same basis that Mr. Lally was trying to get rid of the defense experts, arguing it's not scientific, doesn't meet the, maybe need to have a Daubert hearing on the foundational validity of this methodology, its ability to produce scientifically reliable results. Yeah, I might be challenging that because I don't know exactly what the defense knew was coming from Trooper Paul, or what their expectations were in that regard. But he couldn't even explain really what his methodology was, other than, well, it just did. The evidence was there, and therefore I came up with a scenario in my head that seemed to make it fit. But that's not scientific. That's daydreaming. So I would certainly be considering that if I were on the defense team here. Doesn't preclude the Commonwealth from being able to go and try to get somebody else on board to come up with some sort of theory that could, be consistent with the evidence on the ground. But it would force them to shift directions, shift strategies, and that can, create new problems for them in terms of reconciling a new approach with what they did the first time around, what their witnesses had to say the first time around, and things like that. So I'd be looking at that. Move to exclude Trooper Paul. It was thoroughly unscientific, unhelpful, should never have been allowed in the courtroom. But we'll see. We'll see what they do. I've also kind of given some thought to really the likelihood that the Commonwealth is going to go forward. I've seen a lot of different opinions on this, and it's nobody's a mind reader here. We're all just kind of reading into the situation as best as we can, and I can certainly see a scenario where the Commonwealth, under normal circumstances, you do take a hung jury as a defeat. You were unable to meet your burden of proof. You were unable to convince a jury beyond a reasonable doubt of her guilt. That should raise serious questions in your mind about your ability to accomplish that a second time around. So I've seen a lot of people are of the opinion that the Commonwealth won't go forward and try her again. It's certainly possible. It's certainly possible. I personally just don't think it's likely. And I just have a couple of reasons for that. One is just because of what I've seen from this prosecution already. They don't seem to consider the evidence or the problems with it to be a real impediment to them going forward. I mean, they came into this trial knowing what hand they had to play, knowing that the federal investigators had disagreed with them, and that there was going to be all of this problematic evidence that they would have to overcome. They still did it. It didn't deter them once, so I don't really see that it's likely to deter them a second time. And the other reason is what I've said on many occasions. The prosecutors, quite often, they love to wear that skin suit of that victim. And in their minds, until there is something definitive one way or the other, they have not got justice for John O'Keefe. And so if that is their attitude, then that's just going to favor, pushing forward to the bitter end, one way or the other. And that comes, of course, at the expense of, Karen, more time. Not just Karen, the taxpayer as well. They're going to have to pay to do this all over again. All of the security they've had to bring out, the time they've had to spend on this in court. It's going to take up another however long chunk of the court's time where the judge can't be working on other matters. So there are some pressures against them institutionally like that to think long and hard about it. But if they want to go forward, ultimately that's going to be what decides whether they do or not. I did have a thought about what I think would be a very reasonable middle ground under these circumstances, because I appreciate that the family of John O'Keefe, they want some kind of closure as well. I definitely appreciate that. And a hung jury, it gives nobody closure of any kind. The middle ground that I think would be reasonable under this circumstance is that you would dismiss this indictment and you would take the case back to the grand jury. And then you would not just present the cherry-picked stuff that Trooper Proctor produced, up to whenever it was June of 2022 when the first indictment came down. You have a lot more information and a lot more evidence now. So present all of that to the grand jury. And then if they still believe there is cause to go forward on an indictment, then I feel like there is some more validation for that process. Maybe they would still go forward on murder too, but maybe they would not. If they had a fuller view of the evidence and not a misleading partial picture of what the totality of the circumstances were, which is really what a probable cause determination is supposed to be. It's supposed to be based on all of the facts and circumstances that are known at the time. So present all of that to the grand jury and let them decide, should this go forward again or should it not? I don't think that's going to happen. I think that would be the right thing to do. I think that would be the ethical thing to do. I think that would be the thing that a good representative of the community would do. I don't expect this prosecutor to do that. But you know, I can dream. I can have my own pipe dreams. Let's see what you have for some of your comments, guys. Mad World, the juror Bev Vader chose has proven the corruption wholeheartedly. I just don't know about this, guys. I understand it's an easy way to kind of make sense of the impasse here. But I really have given this a lot of thought, and for all that, in my perspective, my understanding of the evidence, my understanding of the law, I also appreciate, you know, I'm a lawyer. I look at fine distinctions on things like reasonable doubt that other people may not. And I do. I want to give grace to the possibility that people do believe in good faith that she is in fact guilty, and try to understand, try to do my best to put myself in their shoes and understand how that could be. And to my mind, I really think it comes back down to that taillight. I really do. I think they revealed to us what the real heart of the dispute is with that first question when they asked for the cert report. Because the challenge has always been this conflict between these rather extreme positions, right? On the one hand, Karen murdered him. On the other hand, there was a frame job by police. It's not actually a binary choice for the jury if they look at the requirements technically. But that's just the way that it comes off. It looks like you have to believe this one thing or you have to believe this other thing. And part of the reason why is because I think you have to have reasonable doubt about how those taillight pieces ended up at 34 Fairview on the night of January 29th. If you're going to acquit her, if you're going to say, you know, beyond a reasonable doubt, if they were required to make a finding that she was framed, right? But so if she was not framed and those taillight pieces were legitimately there wasn't enough time for the police to come back and set that up. They just don't buy it. The pieces were under snow. No way to get that set up. Then it just raises the question of how did they get there? How did they get there? And so if you don't buy the frame job, or you just don't think that the frame job is feasible, or even you just don't think the frame job explains that particular piece of the evidence, right? A lot of things can be true at the same time, which is a challenge sometimes to deal with in a trial. It's not like internally inconsistent that she could have broken some of her taillight at the scene, and Proctor could have gotten a bee in his bonnet about making sure she didn't get away with it and busted up some more and sprinkled it around. Like, you can have both things happen. They're not necessarily logically inconsistent. So that's kind of my view of it. I think those taillight pieces from January 29th, from that search, was always the challenging hurdle for the defense to have to overcome, because there's just no other explanation, if it's not a frame job, for how they got there, other than Karen had some type of collision, some type of incident there when she dropped John off the night before. I also think that in hindsight, there's always hindsight, and I guarantee the defense team is going to be looking back over this trial with a very critical eye. If they're going to have to do it again, you're going to learn from this experience, and you're going to reevaluate your decisions going forward. That's not in any way like a criticism of them or a suggestion that they've done anything wrong here. I think they did a phenomenal job with what is in many ways a kind of hard case. It's hard to sell a frame job. That's a hard thing to do. But it's just the process of learning. You know, it's the same thing a sports team would do. If you go and you know, you lose a bad match, you study your tape, you look at the decisions you made, you reconsider those, and you reevaluate your strategy. In hindsight, I think one of the just potentially problematic things that happened here was with the crash daddies and bringing in that evaluation from the ARCA crash reconstructionists so close to the end of the trial, and to have them kind of out of the blue introduce this whole new theory that nobody had addressed up to that point. What if John threw the cocktail glass at the taillight? And it makes sense, because if they're just looking at what is the evidence on the ground, what was found, what are the possible ways that it could have resulted in this configuration of evidence that we see, it does make sense that you would think of that. Maybe that's the way it happened, and that they would evaluate that. But it's also potentially one of the downsides of the fact that these guys were not the defense expert, right? The defense didn't have the opportunity to kind of limit them to just the Commonwealth's theory of how the accident happened and directly rebut that, since it was this independent process that the FBI was doing. They didn't have control over that. So it introduced this new possibility that just kind of, created a whole new option for how that taillight could have ended up there. I just don't necessarily know that was super helpful. In an ideal world, they wouldn't have done that. They wouldn't have asked that. But since the FBI had gone down that road, I'm not sure that they really had any choice but to elicit that. I seems pretty likely that if the defense hadn't elicited it, that the Commonwealth would on cross-examination. So yeah, the fact that potentially throwing the glass at the taillight was consistent with what they saw in the Sally Port, as fun as the Cannon testimony was and all that. Ultimately, I don't know if it really helped them to just shift up the mechanics, the potential mechanics of what happened at 34 Fairview that late in the day. So they can reconsider that. They can look more closely into that. They can try to do some follow-up on that. It still didn't satisfy me as an explanation, in part because I never got the answer to where's the rest of the glass. We never found the rest of the glass. The stuff they found in the street, it didn't match. The stuff they found on the bumper, it didn't match. So we just have this partial tumbler right over there by John. Where's the rest of the glass? I would have been satisfied with the explanation that the snow plows over all this time carried it away, except that the snow plows didn't seem to carry away any bit of the taillight. So it still doesn't satisfy me as an explanation, without more. But I also kind of recognize I might be unusually skeptical here. So I do understand the instinct to think of this as corruption, but from my perspective, that's just you need to have proof of something like that, for me to accept that. Just because it's possible doesn't mean that it's likely or that it happened. And frankly, as far as kind of the corruption or intimidation, side of things goes, it's enough for these people from this town to understand where the lines are drawn and that there are sides here, and whose side do you want to be on? I mean, that's enough. There doesn't need to be any explicit, overt effort to influence them. If they're not idiots, they can look around and they can take the temperature of the room, and they can understand the implications of what a verdict either way would mean. So I don't know that changes with the second trial. I think another potential issue that the defense could possibly be looking into here is, do you try to change venue? Do you try to get this trial out of Norfolk County? It's really hard to imagine that after all of the time that this trial has happened and has been going on, and just the weeks upon weeks upon weeks of news coverage, the people who were present outside of the courtroom from beginning to end, that this hasn't caught the attention of just a massive proportion of the community. I don't know. I'm not reading Norfolk County news, but I have to imagine this has been front page, front and center, probably for, most of the entire time it's going on. I mean, it was significant enough when Trooper Proctor testified that the governor addressed it. Okay. I would find it very hard to believe that it wasn't all over local news when something like that happened. So it just raises serious questions about your ability to find anybody in Norfolk County at this point in time who hasn't heard about the case. And for all that hearing about the case isn't, it's not dispositive. You can serve on a jury if you've heard about the case, as long as you can still be fair and impartial about it. Just given the polarization here and the real strong sides, the battle lines have really been drawn. It's just very difficult to imagine that you're going to be able to find a jury pool at this point in time that would be able to come in as clean slates for all intents and purposes. So, not that this wouldn't have gotten coverage in other parts of the state as well, but it's natural. You pay close attention to things that are happening in your backyard, and somebody who's in a more remote area of the state is just less likely to be interested in, except maybe casually, in what's going on down there in Norfolk County. The people who are driving to work every day and, have to detour around the courthouse or whatever, have a hard time parking down there because of the number of people that have been attending. They're going to notice. They're going to notice, and they're going to be paying attention. So it wouldn't shock me to see that either, if there's a potential motion for a change of venue at some point. Benjamin Love, is Reed free of bond and free until they formally recharge? Should she take a vacation where no extradition treaty? I would not advise that. Not that every place that has no extradition treaty is a terrible place, but there is a trend. Not necessarily places you would want to be stuck in. And the reality is, she wants to be exonerated anyway. She wants the closure just as much as the O'Keefe family does, as everybody else does, because it's her name that's been on the line. She doesn't want a cloud hanging over her for the rest of their life. Oh, there's that lady who probably murdered her boyfriend. She doesn't want that. So I don't know that it's in her interest to do that. So as far as the process works, there's no recharge. This is still the same case. It's the same indictment. They're just going to set a new trial and go forward. So typically, whatever release conditions were already in effect are going to remain in effect. The fact of the trial isn't like a change in circumstances that affects, her danger to the public or her likelihood that she would abscond or anything like that. So typically that's not gonna change. It's just going to maintain the status quo. They'll go in on the status date, and I would expect by then there would be some preliminary thoughts about things like, are we going to move to change venue? Because if they do, there's no point in setting a trial date in Norfolk County. You would need to get that adjudicated and decided before you go through the process of setting a new trial date. If nothing like that is on the table, or perhaps they haven't even decided yet, then they'll just set a trial date and everyone will get ready to do it again. Dude McGuy, if cover-up theory is true, then mistrial is a huge benefit to Canton PD, who can keep gathering evidence that the FBI has while keeping Karen on the hook to stay their hand. This is kind of dependent on the FBI's willingness to continue disclosing what they have, to keep showing their hand. When they did the initial Tuey disclosure, That's just covering what they have up until that point and what they feel like they can disclose without jeopardizing their own investigation at that point in time. I've mentioned before that one of the possible explanations for why the feds have not moved on this, if this is something that that they're pursuing, they see a problem with, and so forth, assuming that they either have or are ready to go get indictments on certain people, that you have the benefit of the trial being a perjury trap, because they can't go interview their targets without, there's specific processes they have to go through. If you're under federal investigation, they have to send you a target letter. They basically have to let you know that you're the target of the investigation, what they're investigating you for, and that they want to interview you, that you have the right to your attorney to be present, you have the Fifth Amendment rights, all of that kind of stuff. And so most people prudently should don't talk to them. Don't talk to the feds. Just don't do it. If there is nothing on the table for you as an upside, and there almost never is, unless they are making you like an explicit offer that you are aware is a benefit to you, you don't talk to them. You don't do that. So they wouldn't be able to go and interview these people to get them on record with their version of events. But everybody who chose to testify chose to put their version of events on the record under oath. And so that's all available to the FBI now as well. So I don't know that I agree that it's going to necessarily help the Canton PD one way or another. The trial hasn't stopped the federal investigation. I mean, it's or at least it wouldn't. There's nothing about it that necessarily, would prevent the FBI from going forward and doing whatever it is that they're doing, following up whatever leads they think could lead to proof of criminal activity. So I think to the extent there was a benefit to Canton PD, that's already happened. It happened with the Tuey, and when the feds voluntarily tipped their hand to let everybody know. They've been looking at this. They've been looking at this, and maybe we don't know exactly who's being targeted, who's being looked at here, but there's enough people that, from my perspective, have cause to be concerned about their shady activity, that they already got that advantage when the Tuey disclosure came down. So I don't know that it helps Canton PD, other than it is not a vindication of the cover-up. So it's not a referendum, if you will, on the integrity of the Canton PD. The jury wasn't unanimously convinced that they were wrongdoers in this investigation. So in that sense, it might give them a little bit of a political shot in the arm, but I mean, not really, because this whole trial has been so damaging. This whole trial has been extremely damaging for both the Canton Police Department and the Massachusetts State Police, with the failures and the disregard of the conflict of interest limitations. And that's just before we get to the absolute embarrassment that was the evidence gathering. Like, I have to use irony quotes when I say evidence collection and storage, because, red Solo cups, really, I mean, we've gone over that a million times. So I see that there has been a press release that the DA does intend to retry her. I've got it pulled up here. It says it's a press release from the office of Michael W. Morrissey, Norfolk District Attorney. A mistrial has been declared in the matter of Commonwealth versus Karen Reed. Judge Beverly Cannoni set a status conference date of July 22nd, 2024 at 2 p.m. in the Norfolk Superior Court. First, we thank the O'Keefe family for their commitment and dedication to this long process. They maintain sight of the true core of this case to find justice for John O'Keefe. The Commonwealth intends to retry the case. So that's their statement. They're going to do it. They're going to do it. And I'm not shocked. I'm not shocked. They were already all in on it. What did I say about the skin suits? What did I say about the skin suits? Is that a little nod to, that decision in closing to have those certain witnesses over there sitting with the O'Keefe family, a little message about whose side are you on? Whose side are you on? Disturbing stuff to me. Alyssa Ramirez, are you going to cover YSL judge recusal? So I'm not probably going to follow that real specifically. There's a lot of people that are on this, and the YSL trial is massive. I'm very far from up to speed on it. What I am interested, though, is that I did hear that a transcript of the entire in chambers, the ex parte conversation is going to be made public. So I am going to be keeping an eye out for that, and I may cover that part of it just because that's fairly limited in scope, and that's where potential problems are likely to be evident. So I will be keeping my eyes out for that. But as far as what this is referring to, I don't know if you've been following that at all, but Judge Glanville had made a series of very just problematic rulings, and today basically he backpedaled major, recognized, as everybody else in the world pretty much had already recognized, that he was going down the wrong road. So he has kind of temporarily recused himself until basically issues relating to his ability to continue on in the case can get resolved. Nope. If the defense excludes Trooper Paul, doesn't that open the door to the Commonwealth finding a more credible sounding witness? Would that be a strategic error? Well, there's a couple of thoughts to it. One, is a more credible sounding witness going to be able to give them anything to work with? One way of looking at this is that the reason why we had Trooper Paul at all is because if you imply the basic scientific analysis, you're going to end up where the ARCA experts ended up. They were the ones who were coming in impartial. There's also not going to be an unlimited budget for the prosecuting attorney to go after her, especially a second time around after you were already unable to convince the jury, of your view of the case. So it's certainly possible. You can't rule it out. There's nothing preventing them from doing that anyway, from recognizing, wow, Trooper Paul was really a train wreck. If we want to have a better chance at getting a conviction the second time around, maybe we better line up somebody who's, a little bit better able to articulate and substantiate a coherent theory of how this could have been a murder by Karen Reed. I'm just a bit skeptical of their ability to do that. I think the problem is we all, as we were watching the trial, were able to sit and think through what possibly could have happened, right? What are possibilities? And we talked about things like, oh, maybe he did throw the glass and hit the taillight, but then he slipped. He was so drunk, like she's already driving away, and he threw the glass and broke the taillight, but he's so drunk he slipped and cracked his head, and that's that. Something like that. To me, that doesn't, it still doesn't work. It still doesn't work. I don't know how you get the eye cut. I don't know how you get the blood all down your front, all the way onto your shoe. Don't know how you get blood all the way onto your shoe. And I don't see CPR either. I've seen a lot of people like, oh, the blood on his clothes, that could be the CPR. Not on his shoes. Nobody's doing CPR on his feet. Does not explain it to me. That is a man who is upright and bleeding, in my mind. So there's just so many things that an expert would have to reconcile that it seems very difficult to come up with an explanation, because you would think the ARCA guys would have come up with it, right? What are the possible ways that this could have been a murder with a car? And having ruled those out, I think you're just left with more remote kinds of possibilities about what it could have been. Is that enough to get them to proof beyond a reasonable doubt? Boy, not in my mind, but now I just don't know. I don't know if the jury is putting a lot of weight in, I hit him, then maybe it would be enough for them. Maybe it would. So I think bottom line, frankly, it's better from my perspective. This is like the conversation we had about bad poker. How it's often, I would rather play against really good poker players than against bad ones, just because at least we're all on the same page. We know what the rules of engagement are. We're not being caught off guard by somebody who's just so completely lost with what they're doing that what they're doing doesn't make sense. Like their plays don't make sense. It's kind of like that, I think, with the scientific evidence. It's potentially almost better to have a valid, at least a valid theory, at least something that's grounded in something, because you can meaningfully rebut it. You can't really do that with somebody like a Trooper Paul, because it's like you have to kind of accept that is facially ridiculous. Or not. So for me personally, yes, you're right that it's a strategic consideration, and you have to evaluate that anyway. I'm just not sure that there is a real significant downside to doing that, to getting him off the table. And if you're going to put forward a theory, an accident reconstruction theory, at least for heaven's sake, make it be scientific, and then we can address it on its own merits. Michelle Hemister, if there is a retrial, do all pretrial motions get reviewed? Typically not. There can be some exceptions. So like motions in limine can sometimes be revisited. Third-party culprit could be revisited. This is another potential upside for the defense in all of this. They have now had the opportunity to present their proof that something other than mere suspicion, was going on here. So when the trial results in evidence coming in that could, potentially change what some of those preliminary rulings had been, you can typically revisit some of that. Doesn't necessarily reopen the door to like relitigate everything. I don't know that they could go back and, for example, like go back after Morrissey again. It's just that's already been decided. There's nothing about the trial that really undermines that potential ruling, whether they should be involved or not. But at least some of those evidentiary rulings, the door isn't closed. It's they would need a reason why it's different now in light of what you saw at the first trial. But if they can show that, then they can typically revisit things like that. James Casatelli, now that it's done, how would you rate each attorney on their performance individually and as a team? I think, so starting off with as a team, this is, like I said, this was not an easy case. I mean, for all that it seems to many of us like a very clear case for probable cause, just from a pure psychological standpoint of being able to convince people that police framed her, that is a tall order. That is a tall order. And I think the fact that they from my perspective and my view of the public reaction to this trial, the fact that they were able to convince so many people of that, to me, it looks like an overwhelming majority. I mean, I don't know that there's, anything that's absolutely statistically sound out there, but just a lot of the consensus of the people who are watching really seems to be in all of the different places that you go look, really seems to be in favor of not guilty. So, I mean, I gotta give him an A. I gotta give him an A on that. It's an A job. A+ would be a not guilty. I mean, but that is a lot. That is a lot to ask for. I suppose if I were going to be slightly critical, I could say A- because they could have left a little bit more room to just argue straight reasonable doubt instead of more of the binary. Either she murdered him or she was framed. I'll settle on A- for that reason. Each attorney, I'll start with Ms. Little. Her role was pretty small. It was pretty limited, and it was also pretty much in the background. When she did step forward, she was very prepared. She knew what the assignment was. If there was a small criticism of her, it was that I don't know that she was super adaptable to what she was getting from the witness. But the other way to look at that is that she stayed disciplined with her game plan. She did not deviate from her game plan just because of something, that the witness came up with that a different attorney might have riffed on. She did not do that. So I'm going to give Ms. Little an A. I think she did a fantastic job for what her role was, and clearly having all of those experts coordinated, being familiar with what they said, what they had to work with, what their reports were, and being able to stay disciplined with that. That's great lawyering. That's what you do. That's how you do it. Mr. Yannetti, boy, that opening statement was just phenomenal. It was just great. So good. The only real stumbling block I remember Mr. Yannetti hitting was when he had Matt McCabe on the stand, and he did ask the one question too many. He asked the one question too many, and he got popped in the nose with that. That was when they were talking about that group text about tell them the guy never came inside. And he had been implying that the they was the police, but then he made that mistake of asking the one question too many. He asked Matt McCabe, who is they? And Matt McCabe said it was Channel 4 News. And I think that caught him real off guard. He wasn't prepared for that. It stung. He wasn't ready for it. So that was one misstep over the course of a trial this long. Hard to be too critical of that. I saw some people suggest that he may have come across as overly aggressive with some of the witnesses, as just unnecessarily hard on them or something. I don't know that I necessarily agree with that. It's something I've talked about before. I just feel like that's kind of his demeanor, and I'm not sure that doesn't work in this area, in this part of the country. There just is a little bit more bluster in how he presents. He is a little bit of a tough guy. But I don't think that necessarily comes across as like a bad thing. But I also recognize other people clearly have a different opinion about that. They could see it. They could see it that way, that perhaps he was aggressive when he didn't necessarily need to be. So with all that in mind, I think I would give Mr. Yannetti, I'll give him a B+. I'll give him a solid B+. I really like Mr. Yannetti. I really liked him. I enjoy his style. I have empathy for him and just the struggles he had with this court, with this judge. The way that she was dressing him down for trying to make his record and make his point, when, from my perspective, yes, he has every reason to be outraged when the Commonwealth is misrepresenting what he said and suggesting, he's dishonorable or going back on his word when he made no such commitment. And that was clear from the review of the transcript. So I would give him B+. Mr. Jackson, I feel like in many ways has to be held to the highest standard because he seems pretty clearly to be the leader of the team. He was the one who was, from what I can tell, driving much of the strategy and the decision making and stuff like that. He's the one when we would see them, working over the weekends and stuff. It was typically Alan and Karen. Not that Mr. Yannetti didn't participate, but it just looked to me like Mr. Yannetti was a little bit more of the local counsel. Since Alan Jackson isn't licensed in Massachusetts, he's got to have somebody who's licensed there to supervise him. Sometimes it really is pro forma, right? You're literally just there to sign off on whatever they do and sit there in court and pretty much just make sure they're not violating any of the local rules or the ethical rules or anything like that. But you have no role whatsoever in the strategy or research or argument or development of the theory, anything like that. You're just there to kind of be the hook into that court. But that's not the impression I got of this allocation of labor on this team. They clearly made room for Mr. Yannetti to participate, but it did look like Mr. Jackson was in charge of calling the shots. And so that means he's got to take the hit to the extent that, if there's an expectation that there should have been an acquittal, he's the one, it's his strategy that I think has to be kind of under the magnifying glass in that sense. I can't fault him for pursuing what I continue to think is a high risk, high reward strategy, the going all in on the she was framed. I have to assume that part of the reason why you do that is because that's what your client wants to do. I don't think this is a situation where, he made decisions that he had to persuade her about that. She clearly is adamant about her innocence. And so that, just given the facts of this case, kind of did necessitate taking a pretty hard line on that. Could he have left more room to argue reasonable doubt? Yeah, he could have. I appreciate it's tough with a 1 hour limitation in your closing argument. But that's the gig. That's the gig as a lawyer, is just refining it down and refining it down and refining it down to get to the pieces that are fundamental, the stuff that matters the most. You can't always cover everything that comes up in the case. And when I was taking trial practice, I took trial practice in law school from a long-time public defender in the San Diego County Public Defender's Office. Had done, hundreds of trials, high-profile trials, televised trials. He was a phenomenal lawyer. I got to see many examples of cases that he had worked on. But that was so much of what he distilled to us about trial practice, is that, yes, it's a distillation process. There's just so much that you have to be able to sort it down to things like, what are the top 10 most important things? I realize there could be 20 things in the case that are important, but the jury isn't going to remember 20. And by the time you're done explaining 20, it's just going to be too confusing for them. So you got to be able to distill it down from 10. And then from those 10 pieces of information, how can you put those together in the most simple way that communicates to the jury what do these 10 pieces of information tell you about the case? He called that like the headline, like as if you were a news reporter writing about this case based on these pieces of information, what's the headline of your story going to be? That's your job as a lawyer. That's what you have to do. And that's also part of the gamble, because I can see, even just looking at the commentary, people's reactions on Twitter, everybody reacts differently to different pieces of evidence, different things that hits them in different ways. I mean, for me, the group text that just was the absolute worst was that one about if they don't interview Carrie Roberts completely, that's on them. To me, that said so much more than really anything else in those group texts. But that didn't hit other people the same way. It definitely didn't hit the defense team, the same way. They really didn't focus on that. But to me, that just told me so much about they're not only not interested in this case being solved, but they're happy. They're happy if it doesn't. They're happy if they don't ask the right questions. Like it told me everything about this friendship that they claim to have with John O'Keefe, and this deep concern that they're professing to have his murder solved. That text said it all. So if I'm the lawyer, making this case, I see that, I'm like, ooh, that's going to be one of my top 10. I'm going to work that in. But the different attorneys are going to have different strategies for that kind of thing and different perspectives on it. And maybe I would have been completely wrong, because obviously that didn't hit everybody else the way that it hit me. But then everything else that you do, it ends up being a downstream product of those decisions and those perspectives, right? Because if I had focused on that, it could have changed the way that the case gets presented, the message that comes out of the case. Because I probably, would have focused more on, look at how much they didn't want there to be an investigation. And do you really think that their law enforcement friends in Canton and in the Massachusetts State Police didn't know that this is how they felt? You don't have to have explicit directions, go fix this. That's all you need. That's all you need. You didn't want it solved, and they would know that. That was a little bit of a detour as far as talking about Mr. Jackson's performance. He had a tough task, and I don't think that necessarily expecting acquittal really in any case is that reasonable. There's just so many things cut against it. So many things cut against it, from the very just basic inclination of people walking into the jury room and seeing the person sitting at the defense table and thinking, I wonder what she did. You're always coming from behind as the defense. But they had a lot to work with. I'm just, could they have done more with what they had? I don't know that I'm prepared to say that. Just because there are areas where I might have done things differently, it doesn't mean that it would have been better. I'm not about to say, I can try a case better than Alan Jackson can. I mean, for heaven's sake, he did a phenomenal job with what he had to work with. So, where I think I am going to kind of critique, I'm not going to say criticize, I'm just going to say critique Mr. Jackson on this one. It's going to be on the all or nothing, the heavy emphasis on the all or nothing, not really leaving enough room for just reasonable doubt. Even just address that in the closing arguments. Focus on that for just a couple minutes, more than just the offhanded repetition of the moral certainty standard. Explain to them how it works. If there's alternative explanations, reasonable alternative explanations for what you see, that's reasonable doubt. Didn't really, in some respects, focus on the weaknesses. I think as much as I really enjoyed Mr. Jackson's closing argument, I do think that a potential failing of it was that it tended to speak more to people that were already leaning in that direction. I don't know that it did much to reach somebody who was leaning the other way. And so addressing some of the weaknesses in the case could have gone a long way to help that. Like, the I hit him. You know, address that head on, not just how it evolved. Can we even really give it credit? But let's steelman the Commonwealth's case. Let's say she really did say that. Are we prepared to say that she couldn't have been wrong? Are we prepared to say that it's completely unreasonable given her mental condition at the time? She's clearly distraught. She can't remember all kinds of details about what happened. Is it really that strange that she might think that she had? He focused very, very, very much on the strengths of the defense case. But the weaknesses, I feel like he didn't. And then that did leave that opening for Mr. Lally to just step right up. I hit him. We knew that was coming. I think Mr. Jackson, he knew it was coming too. My view, I think he should have addressed it. I think it might have helped. I think it might have helped give the folks who were on his side in the jury room a little bit more to work with in terms of addressing contrary opinions. So all that said, I'm going to give Mr. Jackson a B. I'll give him a B. He did a very good job with a very difficult case. And the main reason is because I feel like I do have to be a little bit harder on him just because the buck stops with him. If he's the leader of the defense, then I have to attribute a lot of those strategic decisions and things like that to him. Boy, that was a long answer to a good question. Mad World is now a YouTube member. Welcome. Thanks so much for joining. Anton Ivanov, journalist. Jurors were crying and looked pained. This was not an easy process for any of them, I'm sure. I'm sure they spent so much time on this. I don't know what was going on back in the back room, but it's often not real friendly. It can often get real personal, real cutting, real unpleasant, especially if people don't like conflict. If you like conflict, you'll probably like being on a jury. If you don't like conflict and it makes you uncomfortable, then yes, having those disagreements like that is going to be extremely distressing, very distressing, and they would just want it to stop. That's part of how unanimity is possible. Some people just want it to stop more than they want to have the principled stand. Which is, it's unfortunate, but I'm not gonna fault anybody for that. It's a difficult, very, very difficult position to be in. So that is unfortunate, but can't say honestly that I'm really surprised. Bird, the Norfolk County DA states plans to retry. Yep, we saw the press conference or the press release. And Span 65, can Bev be removed from retrial due to bias shown? They could potentially file a new motion to recuse her, but I don't think it would go anywhere. It's just not real clear that she did anything that wasn't within her discretion. I didn't like a lot of her snappy. The breaking point for me was that comment to Mr. Yannetti address it to me, not to the cameras or whatever. You know, I don't know that she exactly said that, but it was clearly what her message was. I don't think that they're likely to win that motion. And so given that, I don't think that it's probably prudent to put a lot of resources into making that effort. I think, you know, something that I haven't really considered, but I would have to if I was going to be contemplating a motion like this, is honestly, I don't know what the alternatives are. And I don't know if the alternatives are any better. Are there judges in the Norfolk County Superior Court that wouldn't have a lot of these same problems in terms of the political connections and the just inherent friendliness to prosecution and police, the people that call you, you know, over the weekend to get their search warrants and chit chat and stuff like that? These are the same problems with all the judges. And so I'm, you know, as much as I don't like her attitude, when I look at just her rulings, I don't agree with all of them. I don't agree with letting the Aruba stuff in. And I definitely don't agree with letting the Aruba stuff in when you didn't let the third party stuff in. But I don't see her rulings as really being patently unfair to the defense most of the time. I mean, the example was that decision to give the Bowden instruction. Now, granted, to me, that wasn't even a close question. Of course you give the instruction. She shouldn't have even been considering not giving the instruction. But the bottom line is that she came down the right way. She gave the defense what they wanted and, you know, not what the Commonwealth wanted. I think similarly, there was another ruling like that she made. I'm trying to remember now off the top of my head. It'll come back to me at 4 a.m. tomorrow. You know, throughout the course of the trial, I didn't always like her rulings, but she did seem to rule for the defense, you know, when it was appropriate. Oh, the other one I was going to say was, you know, the one when she's all sucking up to the Commonwealth. But, oh, you did such a good job briefing your argument that they should be able to use hiring a lawyer as consciousness of guilt. I don't agree with sucking up to them about that, and I think that you should admonish them. I really do. I think you should admonish a prosecuting attorney who would raise that argument, because to me, that's a prosecuting attorney who doesn't care about having a clean trial. That is such an overtly appealable issue. It is so crystal clear that unless you are providing some black letter case law that says this is going to be okay, no problem, total exception to that ordinary rule that you have a constitutional right to be able to have an attorney, and you can't draw any kind of adverse inference from that. If you got some black letter law you can cite to support that, great. But if you don't, then you are inviting a big problem on appeal. And if I'm not so smart as a judge and I'm trusting you to not lead me astray with my rulings, you betray that with this type of issue. So my view, you should admonish that person. But, you know, she didn't, but she didn't let him do it either. Didn't let him do it. That whole consciousness of guilt instruction that they wanted to suggest, oh, you know, these things that she did suggest that she was guilty, yada, yada, yada. She didn't give that either. The Commonwealth wanted that. That was kind of important to their theory of the case. All of these little things, you know, the ring camera, they couldn't even prove she ever had any access at all to that ring camera, but they really needed to be able to argue these little things. Not taking her shoes off in the house means she's guilty. So, you know, even if she wasn't all that nice to the defense in a lot of ways, and in ways that struck me as very distasteful and made me kind of uncomfortable and made me feel bad for the defense team for having to deal with that, when it came down to the rulings, most of the time, I think she gave him a fair shot. I do. So I don't think that would be a successful motion. So I don't think they would put a lot of effort into trying to do that. Charles Argo, what if KR cracked her taillight against John's car and the pieces fell on the road when she got to the house? The residents then placed the pieces with Proctor's help. The problem is that there's all kinds of explanations for what could have happened. And normally that is going to benefit the defense. If they had chosen to prosecute it on reasonable doubt and not go all in on the only possible explanation for this is that she was framed by law enforcement, you know, with the help of the McCabe's and the Alberts, then they have a lot more room to be able to raise things like that, to be able to argue, well, you know, we clearly saw she hit it. We don't know at what point. I think with this particular argument, the challenge for the defense is that they don't have her going back to Fairview in the morning. Right? Did she go back to Fairview in the morning? See, this is something that Karen can get on the stand and testify to, but of course she doesn't have to. But of course the jury is going to wonder, why not? If this did happen, why wouldn't you get on the stand and tell us it happened? That's always a challenge. Always a challenge in cases about plausible, reasonable alternatives. Why aren't you getting on the stand and just telling us what happened? Did you go back to Fairview that morning or not? If she went back to Fairview in the morning, I mean, the upside to it sure messes up Trooper Paul's key cycles analysis, right? He can't fit that trip into his mileage calculation. So that's not going to work anymore. But then you get into problems with, what did she see? What was there? Did she know he was there? Is that why she freaked out? I don't know. I don't know. If he wasn't there, did the McAlberts wait until she started calling around? That's when they went and dumped him out? I don't know. If we had heard from Karen, we would just know more to be able to narrow the range of possibilities of what it could have been. And so yeah, that's just always one of the challenges, in the case. How else could the taillight have ended up there? That's a problem. It's hard. It got broken there somehow the night of the 29th is a possibility. Did John throw the glass at the taillight? I gotta remember her statement in her interview to Sergeant Buchanan. They got in an argument and she dropped him off and left. Got in an argument. Did he throw the glass? Is that what happened? Remember when Trooper Buchanan was first in the morning investigating, telling the medical examiner they thought maybe this was a domestic and that maybe he had gotten hit in the face with a glass? Is it possible somebody in the house saw a glass being thrown? Is that possible? I just don't know. I don't know. But that's the challenge. It happened somehow at 34 Fairview that night, and your ability to be able to prove that is limited. You're going to probably have to put Karen on the stand to establish it if it happened that night and it did not happen in the course of some type of collision, with John. She would have to explain that. I mean, if we're going to be able to say for sure that's what happened. She went back the next morning that we don't know of. Same kind of situation. We'd sort of have to have her tell us that. And then the last option is the one that they went with. It doesn't require her to get on the stand and testify. The police put it there. It's a tough sell. It was a very tough, tight timeline. A tight timeline to be able to pull that off. Just the circumstances. You got officers on the scene. This feeds into that whole argument that people who are convinced of Karen Read's guilt have been, saying for a long time, and it's a persuasive argument. You got to put a lot of people involved in this conspiracy for the cover-up to work. Now, I think that argument gets over-egged a lot. It gets exaggerated exactly how many people do have to be involved in a conspiracy. But, police officers at the scene are going to look the other way while somebody's planting evidence. It's hard. That's hard. So I think the bottom line here is it's a difficult strategy to choose between things that could have happened when the only person who could know if that did happen or not is the person who has no obligation to testify. And so even though, no, she doesn't have to get on the stand, and yes, in theory, you can rely on that as reasonable doubt, it's plausible. It's also very natural for the jury to think, if that's what happened, she would have gone on the stand and told us. No reason why she wouldn't get on the stand and tell us. I know they're not supposed to do that, but I'm a realist, and I just try to account for what people are going to consider logical under the circumstances. That one I think is going to be hard to get past. NJ Kathy, this trial is a huge boon to the FBI. Everyone is now under oath. Yeah, I mean, if they were wanting to get people on record with their version of events, this could not have been better. It could not have been better for the FBI. Not only did you get their version of events, but they're under oath. And now if you can hit them with perjury, you got that much more leverage to be able to use against them, get more people to turn, get better plea deals for whoever you're leaning on. Yeah. Yeah, I think it's helpful to the FBI investigation for sure. Brian Bryson, Karen Read murder trial conspiracy police canine expert weighs in. Search on YouTube. He uses a fake arm bit by a dog and the wounds match John's exactly. I did see this one. I think I might have mentioned it. I don't know, couple streams back. I did see it because this is the guy, he was on Melanie Little's channel, I think well before trial started. She had found him, and it was interesting because part of what he did in his own stream that was pretty recent is he revisited the things that he had said on Melanie Little's stream after we heard the testimony from Dr. Russell. And it was kind of, there were a lot of common points there in the things that they had both said that, led them to think, well, this is a dog bite. This looks like something that I know a little something about. So yeah, that was a good watch. I enjoyed that quite a bit. It's a good recommendation. Kim S. Lally must have an all or nothing feeling. Do we know the split yet? No, and I don't know that we will. If the jurors follow that instruction that they're given, that they should not disclose anybody's vote or the content, the discussion in the jury room, then we may not know. We may not. Like I said, it's not clear to me that it's a crime if they do or anything like that. So it's possible somebody could reveal that information, but I'm not aware at this point in time that we know that. Jessica, just subbed your Substack. Never heard of it, Substack. Can you talk about it, please? Yeah, so thanks so much for joining. I've been a little like all in on the YouTube streaming the last few weeks, so haven't been able to push out quite as much on the Substack as I would have liked. But now we're obviously going to get a break, so I'll be heading back over there for a lot of my content. So Substack is basically an email newsletter. It's mostly written content, but I can do videos and things like that. So like when I do a new produced video, not a live because I can't live stream to Substack yet. Fingers crossed. Hopefully they'll get that set up at some point in time. But for now, like if I do a produced video, I will premiere it on Substack before it goes out on YouTube. And that way too, if you don't have YouTube Premium or whatever, Substack, you get it just the direct, there's no ads and everything like that. But it's where I'm trying to do a little bit more deep dive type of content. Like I wrote up a piece about the issues with the taillight analysis, the chain of custody of the evidence, and just some other things like that dive into some of the details with the law, the evidence in the case and so forth. So I will very likely be writing up a piece on Substack that just gives you like some of my takeaways from this case. What did we learn? Where do we go from here? That type of thing. So yes, thank you very much for subscribing, and please, anyone, feel free to join me over there. Sharon Gregg, I can't believe they're going to retry her. Didn't the FBI tell the Commonwealth the first time, don't do this? I do remember hearing something about, they said it would like be an injustice to try her or something along those lines. But it's not within their power to stop it, really. I mean, even if they had their own indictments ready to go and dropped them before this trial even happened, it doesn't stop the Commonwealth from being able to go forward. And I do think that there is a valid perspective that if you look at this trial as just as much a defense of the investigation and the investigators and all of the shady relationships and so forth, as much as an effort to prove that Karen Read killed John, then they really want that conviction. They really want that conviction because they're going to be able to point back at that the whole time. Be like, look, the jury knew that. They knew this was happening. They knew that these people knew people and that, you know, the Sally Port wasn't exactly neutral ground and so forth. And it didn't affect their view of the integrity of the investigation. They really want that. So there's just limited things the FBI can do to really change that. Arla 7247, clip of Canton Council meeting. Citizens very upset. Belief on everyday basis. There's two standards, one for elite townies, another for the rest. So I have seen little clips. I didn't see the most recent meeting. I need to go check Young Jerks. I know he's been covering those. Mike Crawford over there on the Young Jerks. But the ones that I have seen, yeah, it seems pretty clear that there is a big problem in this community, and just a sense, yeah, that there is a divide between who makes the rules and who lives under them, and that some people just get to live under different standards than everybody else does. And yeah, I'm sure that if you're on the outs in that scenario, that's going to be pretty infuriating. That's something you're not going to be okay with. And so a lot of that emotion is spilling out in these council meetings. Politics are hard. Politics are hard because it's not really set up to fix problems like that, other than just waiting till the next election, trying to vote them out. But the whole problem is, if they've got their power entrenched, there's a reason why they're in that position. It's because of the friends they have and their ability to get those votes and land in that office in the first place. And then those people benefit from those connections and that consolidation of power. The people who get the benefits are not going to be real eager to give them up. So yeah, fascinating to watch, and I don't envy them having that kind of issue to have to work through. Scorpid Black Dragon. For retrial, canine trainer can to attack arm injuries. Yeah, they could. I mean, that is the other, that's of course the other possibility of all of this. They can keep working. They can keep working. They can focus group this trial, okay? How big of an audience did they have watching this thing that they can now focus group? What was the most impactful? What were questions that you had that didn't get answered? They can then follow up on everything that they've learned about what went right, what went wrong, and try to fix it next time. They can try to add to what they've already developed for their case. You saw throughout this case the Commonwealth continuing to provide the notices of discovery, and a lot of people were unhappy and outraged about that. Like, what is the deal with during trial they're still producing discovery? Well, it's because the investigation doesn't have to end with the trial, huh? No, you don't have to stop. You get to keep right on going. And if you find new stuff, well, maybe you wouldn't have been able to bring it up in this last trial. Maybe it would be too late. You know, you'd have Rule 14 considerations, but now you got a whole new trial. So, whole new opportunity to be able to evaluate new evidence and new opportunities. Solo YOLO, can't watch another 85 years of Lally and his sigh isn't. Thank you for coverage, mods, and community. Well, you're very welcome. I'm going to see when this trial date is. I'm just going to see when it is. And then I'll evaluate from there. I'm already committed October, November. I am going to be in Delphi. Which incidentally, going back to the Substack, that was my initial impetus for getting the Substack going, is because I'm going to be there in the courtroom. It's not a case where the judge has been receptive to having cameras in the courtroom pretty much at any point. And so there's no expectation that's going to change for trial. It's going to be limited to just whoever is there in the audience giving the reporting. So really critical need for accurate information by people who understand what it is that they're watching and are able to communicate that. So that's my goal. That was my initial motivation with the Substack, is that's where my primary coverage for Delphi is going to be. That said, I don't necessarily want to make too much stuff exclusive, just for subscribers to Substack. I do want my material to be generally available, but at the same time, I recognize, you need folks who are willing to pay me their hard-earned money. They deserve some value for that. So anyway, that's the general plan. That's going to take up my August, November. If this case gets set for August, November, I will not be able to cover it either. But if it's set at another time, well, we'll see. Can't say I'm looking forward to it either. But hey, at least we'll at least we're prepared, right? Forewarned is forearmed. James Brown, will DA have the political courage to retry? I doubt it. He says yes now, but public sentiment's not on his side. Politicians go with the wind. Well, there is some truth to that. And, a big consideration for politicians is always going to be money. It's always going to be money. How much are you going to throw at this? Because your constituents might have other priorities. And I don't know what their situation is there in Canton, but if they're like most communities across the country, they're still a little backlogged with their trials. There's just a lot more cases that prosecutors want to charge than the court system can realistically handle. That's part of why the system is set up for so many cases to resolve by way of plea deals, Because if they didn't plea out and every single person who's charged with a crime went to trial, it would collapse. There's just no capacity to handle that kind of volume of criminal cases. So people pay attention to those kinds of things. They're concerned about that kind of thing. And yeah, is the prosecutor going to have to take money from more serious cases to be able to pursue this one? Are the people going to be protesting? Why are you spending the money on this retrial instead of doing more and further investigation? Maybe, I don't know, evaluating how you can fix these problems that happened with the evidence collection and documentation. Maybe you could put that money towards training people how to use evidence tape. Just a thought. Just a thought. But yeah, I expect he's going to hear a lot in the coming days. I don't know if it'll influence his decision or not. I really don't. But if he, certainly I agree that if he feels that his future, his security in his position is jeopardized by retrying her, then he would back away in a heartbeat. The squid. It'd be interesting to know who the big dummy is on the jury. I don't see how it's possible to have any common sense and not see that John was not hit by a car. Pretty hard for me to see. Pretty hard for me to see. I mean, the evidence from the reconstructionist, I thought was pretty unequivocal. You can't square, you definitely can't square the Commonwealth's theory with the key cycles and everything with the evidence, because 15 miles an hour and above is where you start seeing serious injuries, fractures, avulsions, you know, and he had not so much as a bruise. I guess someone could be thinking it doesn't rule out an accident, a collision at less than 15 miles an hour. But I think the problem is just that if it's a you don't know, it's possible. It's not proof beyond a reasonable doubt. It doesn't meet the legal standard in my eyes. I just think that likely the whole issue with the division came down to a combination of things. One just being disagreement over whether there had been an accident at all. And I think that probably, like I've said, that hinged on those taillight pieces found on January the 29th in the search. So a basic factual disagreement about what the evidence tended to show. And then when it came to reasonable doubt, the moral certainty. Right. The moral certainty, when you look at how the instruction is written, it's very clear the moral certainty needs to be that she did it, that she committed the crime, each and every element of the crime. Somebody really thinks she did it. Really thinks she did it. Yeah, they're not going to want to come off of that. They're told to hang on to their moral certainty. It's a tough one. It's a tough one. I was on Broken Baker last night. We had a great panel. It was so much fun. I got to finally meet Mark Betterow and Brandy Churchwell. Obviously, I've known them, you know, kind of through social media for quite some time, and they're amazing creators, both of them. I mean, Mark has been like volunteering his own time for other people's channels and stuff. Other than Twitter, he really doesn't have his own presence. But just his willingness to go on other people's channels and answer a lot of questions, give his perspective as a very experienced trial attorney is super awesome. So it was great to meet both of them. But anyway, Mark had a point that I think just can't be understated too, which is that we don't know the split. We don't know if it's one holdout. We don't know if it's two holdouts. We don't know if it's 5 holdouts. We don't know if the jury is evenly divided. We just don't know any of that. But if it's a single holdout, one way or the other, that person is the star of the trial, for better or worse. And like a star, not necessarily in a good way, but in an attention way. You were the one that had the most impact on the trial outcome. And so, I can't rule out a situation where somebody would sort of know. They would kind of know that. And that person, everyone's going to want to interview them. Everyone's going to want to talk to them. It could be just a person with a strong, good faith belief in their position. It could be somebody who's kind of trolling. You just never know. But I agree. I would love to know more about exactly what happened. I'm just not sure we're going to get that opportunity to find out. Aaron Guano Loco Mishler. What's the odds of one or more of the jurors letting the public know what led to the impasse or the leaning of the jury? I can't say I think there's a bad chance. Now, that said, they seem to have been pretty diligent with their instructions so far. And even these notes that they sent back, I particularly admire these notes because they just seemed very respectful to everybody on the jury, regardless of what their perspective on the case was. These weren't notes saying, we got an idiot in here who's not cooperating. Can you find them intransigent and boot them off the jury? It was nothing like that. They did phrase it in terms of these are just fundamental differences in perspectives. And so they weren't going to be able to resolve it, but not really pitching anybody as a terrible person or a bad guy or a problem troublemaker or, anything like that. So it does suggest this has been a diligent jury. And if they are, then they're probably going to follow that instruction not to talk about other people's business, other things that were said in the deliberations. That said, is there a decent chance that somebody perhaps anonymously is going to leak it? Yeah. It's just that if it's anonymous, then it's unverifiable, There was, I remember after Depp v. Heard, there was the juror that came out with the kind of discussions about what their thought process had been, but the person remained anonymous. There's not really any way to say one way or another, are we certain that really was a juror or not just a sophisticated imposter? It's just inherently less trustworthy when you do that type of thing without having your name associated with it. So I think something like that is possible, but then it just opens up the question of how much weight do you give it? Now, if somebody does come out with their real face and talks about this stuff behind the scene, that's going to lead me into thinking, well, that's probably a more trolly type of person, right? Because they're disregarding that instruction to not talk about other people's business. You want attention for yourself by talking about other people's business. It's not going to look good. I'm sure I'm not going to be the only person that gets that impression. So, yeah, I think there's a decent chance that we find out, but I'm not sure that it will be a great source of information, in all honesty. Joe Mendoza, could Norfolk County residents file a petition to the Congress people to talk to DA about not prosecuting this again? The Commonwealth is for the people, right? So I don't know exactly what the structure of government is in Virginia, in Massachusetts, but I could tell you that over here in Washington, they cannot do that because the district attorney of the county has independent constitutional authority to basically be able to act independently. They are not just, arms of the state government subject to the state government. The state has typically an attorney general or a state attorney or somebody like that that's there to act on behalf of the state when, state issues are implicated. But prosecution of crime is conventionally, it's a local issue, and it's up to the people who have authority over the local government. And so it's typically limited when the state can step in and interfere. Now, they can always use political means. People can make phone calls, be like, dude, you sure you want to You sure you want to go back down this road? Because we took a lot of heat. We took a lot of heat over how this went the first time. And, maybe we're going to take more heat if this is going to continue. They can always use those type of political means. But as far as having actual authority, like to step in and take over the prosecution, I would doubt that they have it. It's just not typically how local government authority is set up. Jesse Golightly, totally agree with you on the problematic effect of ARCA witnesses' conclusion being left out until the 11th hour. Why was that left hanging? I guess, I have to think maybe the defense just thought it was a nothing. It was a nothing burger because that wasn't what the Commonwealth's theory was. They weren't making the argument that John threw the glass at Karen's taillight. So it was just kind of an afterthought. But it's always hindsight. There's always hindsight, and you just have to wonder, did it maybe just create another possibility in people's minds that they hadn't thought of before? And wow, this would work by the defense's own acknowledgement from their experts, the ones they put on the stand. That would work, and that's consistent with. They had a fight and she dropped him off. What if he threw the glass at the taillight? It's hard not to rule that out, again, without putting Karen on the stand, but you could always have pointed out. You could have pointed out, where's the rest of the glass? Why isn't it there? Why is the glass on the grass? How would that even work? I wonder, one of the questions that I have that I'm just not sure the answer to, honestly, because I've never seen this situation where the FBI has hired these people and the FBI is paying for them to be at trial and is controlling the details of what they get asked and not asked and stuff, and nobody could talk to them until trial. It was strange. And so it makes me wonder if they will be able to do any follow-up. Like ask them, could you follow up on that if he threw the glass and hit the taillight? I mean, can we make any kind of prediction about where the glass would have gone? Can you shoot the cannon a few more times and tell us, like, maybe there's a range? Is there like a, I have to assume it would be a little bit chaotic because it would depend on exactly like the angle that the glass hits the taillight and all that type of thing. But I would still expect like some kind of pattern that you could ascertain, and then would that be consistent with the evidence on the ground? I don't know. But I do think that's a challenge in relying on an expert that's not yours. That isn't answering your questions. They're answering somebody else's questions. And so if this created questions that didn't help the defense, they really didn't have a good ability to be able to follow up on that. John O'Neill. John O'Keefe is injured and Brian Higgins goes to the Canton PD, perhaps to retrieve materials to move body and clean up. Body bag, stretcher, gloves, bleach, booties, Tyvek suits. What else is on the list? I have to wonder about body cam, or not body cam, but just surveillance video inside Canton PD. I mean, they have it in the Sallyport. Are we to believe they don't have it anywhere else in this police department that we wouldn't be able to see coming in and out and what the movements are and so forth, that we're stuck with just the key swipes? It's just so hard for me to believe, especially if they have, I mean, don't they, I don't remember if they said or not. When Sergeant Buchanan talked to Karen Reed, was that at Canton when she made that, they had that recording where she said, are we all in on the are we all in on the same joke? That Brian and Colin beat him up and my taillight's busted and his face is pulverized. Was that at Canton PD or was that at the Norfolk DA's office? I just don't remember. It's extremely common for police departments to have interview rooms in there. That's where you take the people when you're going to formally interview them, because you have cameras set up in the room and they record the whole thing. Very common to do that. Then when you have that, you have cameras outside and around, because if somebody, say, gets out of that room, you want to see where they're going. It's just hard for me to imagine that this police department is not completely covered in cameras. But we didn't see it, so maybe it's not. I don't know. But if there is anything there, I mean, surely we would be asking for it. Jeremy Morton, always weird to me how the reconstructed taillight was missing the middle part, consistent with Proctor not having those middle pieces since they had fallen out after hitting John's car in the morning. 100%. 100%. And that's what stood out to me because I have squinted at that 830 dash cam, the wellness check, so many times, and I've thought about that description that Carrie Roberts gave, that the snow was packed in, it was like compacted in. And I look at that picture of that taillight, and you don't see compacted snow like around the edge. When you look at the reconstructed taillight, it's broken all the way around where it curves. And there's just a little piece that's left on what is basically now the passenger side of the car. So the whole corner basically is gone. So you would not have a nice square corner from compacted snow. You would just have, a blob, a mess. And I clearly do not see that on that dash cam video. I see what looks like a little flaw right next to the tailgate, the hatch, the back door there, where it lifts up, right where that one little middle piece appears to be missing. So that makes a lot of sense to me. That has always made a lot of sense to me. She hit her taillight on John's car. It cracked that one little section. Those pieces fell out, who knows where. That's what Jen McCabe and Proctor and Buchanan and everybody saw, that let them know this is what to build the story around. Build the story around this broken taillight and her being parked out in front of the house. And we'll just pretend he never came inside. And then, and then Proctor, he doesn't have those pieces, but he needs to be able to find something so he can just, little hammer, just get a little sprinkling, get it out there for the 545 discovery by cert. It makes sense. It does. I'm very much with you with your read on that curiosity with the taillight reconstruction. The other thing that I saw, I don't remember now who it was who posted it, and I can't speak for the authenticity either. But somebody had purported to go through and literally match each of the pieces in the taillight reconstruction to the bag where it had come from in the evidence bag. From all that testimony that we got from the forensic scientist, Maureen Hartnett, who did the piece it all, or not Maureen Hartnett, it was the other one who pieced it all back together. And so then we're able to attribute, okay, which person who is identified on the bag as having secured that piece of evidence was responsible for which piece. And it lined up very curiously where there was just big chunks. This chunk was the part that Cert got. This chunk was the part that Buchanan got. And this chunk was the part that Proctor got. And that's just, I can't believe 47 pieces randomly scattered all over this area, and they just happen to be collected cleanly in that type of pattern, it doesn't make sense. They would have just, each randomly found pieces from different parts of the taillight, and it would be like a mosaic kind of situation. If that is the case, I would love to see stuff like that developed more for the retrial. I mean, those kinds of details, if they sincerely believe that's what happened, those are the kinds of details where you can prove it. So I would love to see them dig a little bit more into it. Dollyhood, jury explanation to judge. Was that a low-key burn? I didn't get any burn from it. I mean, I'm trying to think of anything that might have jumped out as a burn. I really didn't get anything. Overall, like I said, I found both of the statements. I thought they were just very respectful, really, of everybody. I think they continued to be respectful and frankly patient with the court, even though this is now the third time they're telling her, we're not going to fix this. If they were really losing it, I would expect, it might be something short and snippy, we're still in disagreement or something like that, like a one line, no verdict. I didn't get that. They seemed very sincere and that they wanted to communicate that they really were trying, but this just really was a fundamental division that they weren't going to be able to get past. Sandy B, do you agree for her to let the taillight in after releasing the scene and no chain of custody? Well, so this is something, maybe I'll make a little note. Maybe I'll make a little note and look up what exactly the law is for chain of custody in Massachusetts. So there's two ways typically that it happens. There's some situations, some, jurisdictions where chain of custody is foundational. Like you have to establish a basic chain of custody to establish authenticity of the item that you're introducing. And so if you fail to do that, the item should not be admissible. There's other jurisdictions that basically say as long as the authenticity can be established in some other way, then any problems with the chain of custody, it just goes to the weight that the jury can give that evidence or not give it. It doesn't affect its admissibility. So my suspicion, just based on what we saw unfold, is that Massachusetts is probably the second kind, but I don't know for sure. And so in that situation, as long as somebody gets up on the stand and, does the holy display of the evidence bag and removes the item with their dirty, tainted gloves that have already handled everything else in the courtroom, as long as they go through that theater so that they can say, yes, this is the plastic that we collected, that's going to be enough to authenticate it for admission, and then the challenges to the chain of custody just go to the weight. But I am interested in that question. Washington, where I am, it's a little bit of a mix of them. Like you have to prima facie establish that the thing that is coming into court was the same thing that was collected, and that any change in its condition has to be accounted for and stuff like that. But if there are, minor problems with it, or areas where like it could have been left out, or multiple people access to it or something like that, generally that's not going to be enough to keep it from being admitted. It's just going to be something you're going to be able to raise to say, hey, can we be sure that this piece of evidence still has integrity? And that may just depend on, what you use it for. Something that's like left out that you're using to try to get DNA evidence from, kind of like these, the clothes and the taillight pieces and all that stuff, is just left out unsecured. Well, that increases the likelihood that whatever you get off of it doesn't have integrity anymore. So To answer your question, I don't know enough of the details of Massachusetts law to be able to say definitively if it's a problem or not, but my suspicion is that it's probably okay for admissibility. They just allow them to argue those problems as it goes to how much weight the jury gives the evidence. Carazola X, I hated how whenever an objection was overruled, Bev wouldn't say overruled and ask the question herself, like only she could ask it. Felt improper. What I didn't like about it was that it just wasn't helpful, especially when there was an objection to something that was clearly like calling for hearsay, right? This witness wouldn't know the answer other than somebody had told them. And she would just be like, well, do you know? People think they know what somebody told them. They don't know what the distinction is between, necessarily this is my personal knowledge or this is something I really, really think is true, because lots of people have told me that. So it just, it wasn't helpful. It didn't really, from my perspective, a lot of the time get to the core of what the actual objection was and what the problem was with the question. So I don't particularly like judges that get involved in stuff. It's not their job to correct the questions. It's not their job to tell either side how to fix the problem. That's not what a referee does. You're there to call the balls and strikes. And if they don't know how to ask a proper question, that's on them. It's not your job to fix it. That's a big part of what I didn't like about it. Big part of what I didn't like about it. But is it illegal? No. No, it's not. It's just, from my perspective, not a very good look for a judge. Jersey Girl 51, love your explanations. Followed you since JD. Thank you. Well, you're very welcome, and thank you so much. Thank you for sticking with me all this time and all these different things going on. We are quite a world away from Virginia and that civil case and Depp v. Heard and all that wildness. Yeah, very different scenario here. Joe Mendoza, can KR file a civil claim for malicious prosecution if this trial was a mistrial and not an outright acquittal? No. And frankly, even if it's an outright acquittal, you can rarely file for malicious prosecution. The exceptions to that are so extremely rare, because the prosecutor typically has absolute immunity. The circumstances that you can overcome that are extremely slim once there is a grand jury indictment, because that provides the prosecutor with almost absolute insulation from any type of claim that they didn't have the right to go forward with it. So barring some evidence, now, fabricating evidence, like maybe reversing a Sally Port video, we never did really get down into who was responsible for that, did we? And now we got a lot of time to maybe be able to look into that before the next trial. Won't that be interesting? Another road we can go down. These are all, by the way, points of leverage too that the defense potentially has to try to push them off a retrial. Just, you realize we're going to go down all these roads. We're going to continue to investigate your corruption as long as we possibly can. Just another option that they have. But no, I don't see a case for malicious prosecution here based on what we know at this point in time. It's so extremely difficult to get over that hurdle. Now, I have talked about the 1983 civil rights claim that she could potentially have against Proctor. Just, if she can show, she's already got him on the hook so much for the tweaking of his reports, the leaving out the critical details, the report that he wrote about Lucky that was contradicted by Michael Trotta and by Lucky Loughran, where he said, they told me it wasn't plowed or whatever, and they're like, no, it's not what happened. Here's the plow schedule. We looked at it. He knew it was Lucky. Things like that can support a claim for a violation of somebody's civil rights, fabricating evidence against you, or, altering their reports. Yeah, that can potentially be viable. It would certainly help, though, if she had an acquittal first, but a mistrial doesn't foreclose. It doesn't foreclose that. So she potentially still has some options. Cargo pilot guy, I always imagined that all lawyers would value our constitutional rights, but prosecutors consistently remind me that they simply do not care. We need more lawyers like Andrea, potentially criminal in government. Part of what makes me and Sean over at Potentially Criminal good at what we do is that we don't want to be part of the government. We don't want to have those levers of power, and I don't want to play in that system. I just don't. It doesn't suit me. I've had for years people suggest, oh, you should think about being a judge. You should. I mean, and not to like. Whatever, like high up people suggesting this to me. I don't want it. I don't want that job. I don't know how I can like draw a line under that any more clearly. It's not a good fit for me. I'm good as a criminal defense lawyer because I'm a contrarian and I like to argue my case because I think the case is right and not because anybody is going to like me or not like me or vote for me or not vote for me as the result of my position. So you have to be, I think, kind of dispositionally not very political to be a good criminal defense lawyer. So this is the problem from the Republic, right? Plato wrote about this. He attributes it to Socrates, that the part of the problem with government is that those who are least suited to power are the ones who want it, and those who would be best at it don't want it. I don't know how to fix that problem because I don't want the job, but I do at the same time. I appreciate your point. To me, my position should really not be extraordinary. It shouldn't. That's what the law is supposed to be. It's about principles, and if you are not applying your principles just as equally to people that you don't like as to people that you do, they are not principles. It's really as simple as that. Catherine Thoure. Once again, thank you, Andrea, Jeff, and chat for all your insights. On the way, Canada Day celebrations here in Ottawa, Ontario. I wish all my American neighbors a happy July 4th coming up. Be well all. Well, thank you, Catherine. Have a wonderful Canada Day. And July 4th, I have to admit, is not one of my favorites because my dogs do not like the fireworks at all. And they've already started here. We've got some exuberant neighbors who rather enjoy to blast large things. I don't hold it against them. I understand it's fun to blow stuff up, but my dogs hate it. And so my silver lining this year, again, I tell you, I'm pretty good at looking for the silver lining and stuff. The silver lining this year is that I think the old dog might finally not be able to hear them anymore. So, and he gets so stressed, extremely stressed out. He will try to hide in the bathtub. He'll try to like dig into the carpet, like dig out of the house. Like he gets very, very stressed. So hopefully, this year it won't. It's just one of the peaceful sides of getting older. He'll potentially be oblivious to all that. So thank you very much and happy Canada Day to you. JT000. A retrial will be grim for Karen Reid and O'Keefe family, but will be fascinating to watch how both sides run their arguments, having learned from this time, given the number of questions we have about what happened. It is true. The run it back is going to be, it's going to be a case study in if you get a mulligan, and your ability to adapt, given what clearly worked for you the first time around and what clearly didn't work for you the first time around. It's going to be interesting to see who is adaptable and in what ways they are adaptable. I'm definitely curious to see, do they keep pushing? You know, does the defense keep pushing? Are they going to follow? They better follow up on that Sallyport video. They better follow up on that. I mean, if we're sticking with the frame job, okay, somebody producing falsified evidence, we need to know how that happened. If that's what happened, we need to establish that's what happened. The Sallyport video doesn't normally come out that way. The metadata on the video shows that there's problems. I mean, we need follow-up on that. So that will be interesting for sure. Joe Mendoza, how likely is it for Lally to practice his presentation skills, organizing his witnesses, and his not being redundant by the next trial? Absolutely none. This isn't his first rodeo. He's had his entire career to learn how to do this. And if he hasn't learned it by the time he's prosecuting murder cases, he's not going to learn it for the retrial. No. And, you know, again, I continue to question how much of this is Lally is dumb like a fox. You know, the Lally-by was very effective in many places. It was very effective with that Sergeant Buchanan testimony, narrating that video, all the drinks that nobody saw. But you had to be paying attention to notice that. And by that late in the day, after that long listening to Mr. Lally, how many people were really paying that close of attention? I was. Was everybody else? Jeff was really prone to the Lally-by. We would have conversations after where he wouldn't remember a lot of this stuff. I'd be like, dude, this is what happened. This is what they said. But it's like in the middle of a long Lally direct, easy to miss. And the whole other side of it too, the perspective that this case was like the trial version of a discovery dump. You know, you don't have anything good. There might be stuff in there that's harmful. So you just bury them in absolutely everything so that, number one, they mistake the quantity of the production for the quality of it. And number two, they are just overwhelmed by the volume and can't pay that much attention to what is in it that actually matters. They just can't sort through it all to figure out what makes a difference and what doesn't. So I do wonder how much of Lally is just not being effective, and how much is it he has found a backdoor way to be effective in this very weaponized incompetence kind of way. Ms. Lily C., what if the officers that testify get arrested or fired before second trial? Well, that would be impeachment evidence. It would, you know, definitely be something that they could potentially elicit, because it would go to, you know, presumably misconduct or dishonesty or something like that affects their credibility as a witness. If they get arrested before the second trial, then there, you know, is a very good chance they would plead the fifth. Even if they testified in the first trial, if they lied, you don't double down the second time. You know, it's each time you lie in court, it's a separate perjury charge. So if you know that the net has tightened and you're getting caught up, I think you're at that point well advised to just go ahead and stop digging your hole. Those are the most obvious consequences that I see. Alex Davy Duke, thanks Andrea for your great coverage. You, Melanie Little, and Runkle are the best. Well, thank you so much. I have to say, Runkle is awesome. He's one of my favorites. I haven't gotten to meet Melanie yet, so I'm hoping, very much hoping, because she's not on X, and we haven't connected any other way. But I would so love, because I know she's like the OG on this case. She's been following it from day one. I really appreciate and value her perspective on it. So I'm just fingers crossed, hoping we get a chance to maybe be on a panel together sometime or something like that, because I would love to put my head together with hers. Mike Durado, this is where I think our country gets it wrong. How is Karen supposed to afford another trial? Loved your coverage. Go Phillies. Yes, go Phils. Go Phils. What a great comeback the other day. Was that not an awesome comeback? I don't love that they have to come back at all. But, you know, this is not our best lineup. You know, we got some of our most important bats are out on the IL. It's that tough time of the season when just the wear of all these games and stuff starts to take a toll. But they're still pulling through in spite of it. So yeah, go Phils. Yeah, I mean, it's a lot to ask, isn't it? The sort of cynical, I guess, straightforward answer to your question is, well, they don't expect her to pay for another trial, because if she can't pay for another trial, they'll appoint her a public defender to represent her, and she'll get a public defender to be able to take her case to trial. And that is the backstop, right? She doesn't necessarily have a constitutional right to have Alan Jackson defending her in the case. She gets that by virtue of having the ability to pay for it. So, but it is a shame. Definitely a shame for everybody concerned, just to not get the closure. And it really is. It's just like the instruction said. The Tuey instruction says, like, it's so unfortunate, because there's no reason to think another jury is going to be able to do better. What basis would we have to think that a second one could get it right when this one couldn't? It's a shame. Lisa Bug, Andrea, do you believe she is innocent? From what I have seen, I don't think she hit him. I don't think she hit him. I don't think there's evidence that she hit him. So, as far as these charges are concerned, yeah, I think she's innocent, because I don't think she hit him. I don't think they've proved that. I think where it gets difficult for people is just sort of around the gray edge, the gray area. Did she do stuff that I don't like? Certainly. I don't like that interview. Wish she hadn't have done that. Baldwin shouldn't have done it either. It just never goes well for you to try to do the PR defense. It's just not a good idea. And I feel like that is very likely what limited her options as far as being able to get on the stand and testify. Because you create unnecessary risk when you're already out there, on record with statements that you're kind of married to. If you deviate from them, then now you look like you're, being evasive, changing your story, stuff like that. It's just not a good idea. But does that mean that she committed a crime? No. Yeah, based on what we've seen, she didn't hit him with a car. So that's pretty much it for me. Jonathan Dean, can governors step in to stop a second trial? Once again, I don't know exactly what the structure of their government is, but likely not. It's not the governor of the state is not like an absolute monarch over there. They typically have divisions of authority and jurisdiction between what's the state level, what's the county level, and no, the governor typically does not have the ability to come in and stop it. Now, I will limit that by saying where the governor typically does have that power is clemency. The governor can pardon them. Governor can typically pardon anybody, whether they have actually been convicted of anything or not. It's just that I think that would be unsatisfying for a lot of people too, because it makes it sound like she did something wrong that she has to be pardoned for. I mean, this, obviously came up a lot with talk of presidential pardons and stuff like that. Oh, it's an admission that they did the crime. It's not. But there's the perception, that it is. that's the effect that it has. So in terms of clearing her name, not sure that would be really really satisfactory. But as far as stopping the prosecution itself, I would be surprised if they have the constitutional authority to be able to do that. Chad Hibbs reports out that it was 11 guilty, 1 not guilty. I find that very, very, very hard to believe. It's, reports that aren't attributed at this point. There's just every reason to be skeptical of them. It's unfortunate, but that's just how it is. It did make it sound from the notes, didn't it? Like it was more than one. I mean, they talked about just we are hopelessly divided. It's not that it ruled out the possibility that it was a lone holdout, but it just, to me, I got the impression it was potentially more than that. I don't know. Just the fact that they ended up hung tends to suggest this was either one extremely strong-willed person or it was more than one, because they had backup. If you have somebody else that has your back and they're not going to back down if you don't back down, makes it a lot easier for both of you not to back down. If it's just one person, then excuse me, then I think there is just a little bit more of a natural tendency that person, they can be pushed over. They can be pushed off their position. JT000, enjoy your discussion and difference of opinion with Betterow about whether to call your client to give evidence in this situation. Tactics equals interesting. Yeah, we have a very classic disagreement, which I kind of analogize to like the difference between classical economics and behavioral economics. Mr. Betterow is 100% correct, and he is in the majority opinion that when you're evaluating whether your client should testify or not, you're just doing a cost-benefit analysis. You're looking at what do they add to the equation substantively, like what evidence can they offer that the jury needs to be able to decide the case versus what is the risk that you have by putting them on the stand. What are the potential bad things that can come out, the impressions the jury can get, and all of that type of thing. And so he is bearish on putting his client on the stand. Me, I'm the opposite. I take a very just psychological approach to the decision-making process of the jury. I tend to think that when it comes to how the jury decides the case, the reasoned application of the facts to the law as it is instructed to them is not typically the way it's done. And it's supposed to be, but it's just that story that we tell ourselves. It's the rationalization of the process. When in reality, and I there's quite a few studies that back this up, that look at jury decision making and stuff like that. They support the idea that juries decide cases very, very early on, and they don't decide them based on the evidence. They tend to decide them based on who they like. I've seen at least one study that suggested that the jurors have made up their minds, for the most part by the opening statements, because they've decided, I like this lawyer, I don't like that other lawyer, which is it's kind of a scary thought, isn't it? It's kind of a scary thought. But if there is some reality to that, then I don't want to stick my head in the sand and pretend that that's not the case, right? I got to deal with the jurors that I have, not the jurors that I would prefer to have. So given that, my perspective is that the jury always wants to hear from the client. And so to the extent I am able to do that without jeopardizing the case, then I want to do that. I want to give it to them. I want to put my client on the stand whenever possible. I wanted to hear from Karen Reed. I really did. And I know I'm not the only one who did. I know that the law doesn't allow us to penalize her for not getting on the stand, but I feel like it would be helpful. I feel like the evidence is very clear that she didn't hit him. And if that's the case, then what's the worst that comes out? That they argued? I feel like I already know that. Did he throw the glass at the taillight? Well, that would explain a lot of stuff. You know? It just, they're so curious. The jury is so curious. They've been watching her this whole time, and they don't know what to think of her. All they have is what they're imagining in their mind, who she is, based on the evidence that's been presented, which is inherently skewed. It's always going to be skewed. The prosecution is trying to make her look like a terrible person, and the defense is trying to make her look like a saint. And the reality is in between. And most jurors are going to be perfectly okay with that. They don't expect you to be a saint. They don't expect you to be a devil. We saw it with Johnny Depp. We saw it with Johnny. A lot of bad stuff he had to deal with by getting on the stand. But at the end of the day, the jury was then able to look at these two people and think to themselves, you know what? That one's honest. That one's not. They just want to be able to get a sense for stuff like that. Total room for lots of differences of opinion on that. And again, Mark is 100% correct in that classical economic kind of way that I don't know that the cost benefit analysis favors it. It's hard to say without knowing everything that the defense team knows. You know, they know a lot more than we do in terms of what is going to happen if she comes up on the stand. What is there that we didn't get to hear because she didn't testify? They're much more aware of those risks than I am, so it's easy for me to just, you know, imagine the best case scenario. But like I said, I account for that stuff. I recognize, yeah, there are certain things that will just be, they will make it impossible. You can't do that. But everything else being equal, if that's not the case, I sure would prefer to do that. Go Georgia. Thanks for such good company and expertise during the trial, Andrea. Well, thank you all for joining me. It's just great. It is. It's great to have company. It's great to have the mutual perspectives on this thing and to just be able to check what we're seeing against each other, especially when we're being gaslit. Good to remind each other, nope, you're not crazy. I saw it too. So thank you all for being part of that. Aaron Guano Loco Mishler, with all the local publicity, would a motion for a change of venue be a viable option? I would be shocked if they weren't looking at it. I really would. I can't imagine that the local coverage hasn't just been continuous and pervasive, and even beyond just the publicity, the press being in town everywhere, the activity that's going on down in the courthouse. I just have a very hard time believing that there's a substantial portion of this community that hasn't been influenced by that. So the question becomes, how do they do that? You don't get to just rely on the fact that there's been a lot of media coverage. You have to show that it has affected the jury pool's ability to be impartial. So there's two basic ways that typically happens. One is what we saw over in the Koberger case. You survey. You hire somebody that does this type of work. They randomly select people. They ask them about their exposure. They ask them about their attitudes to the case. And they use that to analyze the effect of the media on people's perspectives. That can then give you a foundation if it comes back that like, hey, no, this is tainted, and here's how the process works, and so it's very unlikely that these jurors are going to be able to set aside what they've learned as a result of the media coverage. That gives you a factual basis to argue for the change of venue. If you don't do that, and that can be real expensive, all of this stuff costs money. This is the hard thing about being in Karen Reed's position. All of this stuff costs money. The alternative is typically then you're waiting until you're doing the jury selection the next time around, because now you have the actual pool in front of you and you get to ask them about what they've seen, what they've learned, what they witnessed in their town the last time around when this trial was happening, their perspectives on it. And if you have problems at that point, then you go ahead and you make the motion to change venue then. It's not ideal. Nobody likes it. Nobody likes having a whole jury panel called in and then you realize, oops, not going to be able to do anything here. It's not ideal. It's a big limitation in the system, I think. But it's just because jurors are presumed, they aren't presumed to be biased just by virtue of the fact that they have read or seen about the case. And that's an old premise. Dates back, quite a way into the law before I feel like we had a real modern understanding of bias and how it works and how it affects people and how it's unconscious and all of this type of stuff. So maybe that's not a good presumption to have, but the law does not tend to change quickly. So if that ever changes, I don't expect it's going to be anytime soon. Alyssa Ramirez, did we ever find out who made the proffer from pretrial motions? No, not that I'm aware of anyway. It was just that offhanded reference that we got from David Yannetti during argument on one of the motions where he referred to Brian Higgins's federal proffer. And that's it. So we know it exists. We know he used those words. We know those words have a very technical meaning in criminal justice, but that's all we know. We don't know why he was giving a proffer. We don't know what the proffer was related to. We don't know for sure that he meant a federal proffer. I'm pretty sure he did. Can't think he wouldn't have been corrected. I mean, Bev knows. Bev is a former public defender. Bev knows what a federal proffer is. So if that was not in the materials, I have to think that would have been corrected. La Kong Express, did they find Karen or John's DNA on that straw? Please free Zachariah Anderson. Mailboxes. I don't believe they did. Let me, if you want to give me a sec, I'll pull up my notes. All right, let me hunt down the forensics. But no, I don't believe they got anybody's DNA off of the straw. Let's see, that was Andre Berto, I believe, did all of that DNA testing. Andre Porto was his name. There it is. Let's see. Okay, here's the tail light. Here's the bumper glass, the drinking glass, then all the stuff on the jeans, unstained area of jeans, the shirts, the fingernail clippings, the long sleeve shirt, the gray shirt. I'm not sure that they tested the straw. I'm not seeing anything from the testing of the straw, so I'd have to go back and verify that for sure. But what I have here is they tested the passenger side tail light pieces from 3.1-1. The sample from the glass on the bumper, there was insufficient DNA to analyze. The sample from the drinking glass was a mix of 3. Stain A on the right leg of jeans was a mixture of 3. Stain B was a mixture of 3. Stain C was a mixture of at least 2. Stain D was a mixture of 3. Stain E was a mixture of 2. Unstained area was a mixture of 4. Let's see, the orange shirt. Well, let's see here. My notes got confusing right here. The fingernail clippings were a single contributor. I think the orange shirt was a single contributor. The long sleeve shirt, one swab was a single contributor. One was a mix of two. The unstained areas was a mix of two. They could not generate profiles from the right instep of the sneaker, which was a mixture of at least 5. And same for the front of the shirt, I think the orange shirt, and the back of the sleeve of the long sleeve shirt, there were more than 5 contributors. So that's what I have in my notes for the DNA testing. Nothing about the straw. Tracy Fagan, I wanted a picture of the taillight without snow before it was loaded on the tow truck. Oh, for me, I said game over. If they did not document the condition of this taillight when they seized it, then I just have a very hard time buying anything they have to say about its condition. I just have no assurance that that's how it was when they got it. And that isn't even just because they might have busted it out and framed her. You know, it's because things like you drove at 40 miles down the highway and like rocks can get thrown around and stuff. I mean, you know, things can happen. Things can happen. Inexcusable, completely inexcusable to not document it at the time they seized it. They both made such a point about what, you know, it was like such obvious evidence to them that Buchanan calls Proctor over to make sure he looks at it and sees it himself. And yet you didn't think, let me pull out my phone and take a picture. Inexcusable. We should not have to rely on the cops' words about stuff like that. If they are forcing me to rely on their words over something that could be easily verifiable, to me, it tells me that verification wouldn't be in their interests. If verification would support their version of events, they would document it. Simple as. Wooten Bucket. If Karen was reversing when John threw the glass, the momentum spilled taillight pieces on sudden braking. In a pee-off mood, John enters the house. I can see a lot of ways this went down. I could see a lot of ways that this went down. Yeah, they fought. And he goes inside all pissed off. What did they fight about? I mean, what are the likely things that they fought about? I guess they could have continued the fight from the morning, but it sure seemed like they were over that at the bar, didn't it? So what were they fighting about? I don't know. Maybe Higgins and the so? Well. Well, it was well. Oh, man. Yeah, and then that whole, what exactly was going on? What exactly was going on in the waterfall video? Right when Higgins is getting ready to leave. Sure looks like he's getting hot about something. I can think of a lot of ways this would have gone down. Shy Gal 8. Sorry about Mimi the cat, Andrea. She likes to sit on keyboard. Well, cats are like that. I understand. I was never much of a cat person, but I did have a cat. I have one of those stories of I didn't like hate cats or anything. We didn't have them. We always had dogs, so I really didn't know them, and they seemed kind of standoffish and a little rude to me. My cousin had a cat, and the cat would wake us up at like 3 a.m. by getting in the bed and biting our feet, and I didn't like that. So I was not necessarily the biggest fan of the cats. But I did have a cat that decided that she was mine. I had no role in that decision. It was entirely up to her. And so she moved in with me and lived with me for about 15 years, I think, maybe a little bit longer. She also liked to sit on the keyboard. So I understand how it is. You'll get no judgment from me. Emma Daisy, what would happen if there was one guilty holdout and the FBI found a connection between that juror and either the O'Keefes, Alberts, McCabe's, Morrissey, or MSP? A connection alone wouldn't necessarily cause anything to happen. But if there is evidence of influence, then that's jury tampering, and that would be a very serious crime. If they could prove that, it would be a big problem for everybody involved in it, both the juror and the person who is trying to interfere with the deliberations. Lousy David. All right, Ms. Burkhart, you are all set. For now, anyways. You are one of 3 attorneys I watch coverage with, but you're definitely my favorite. Well, thank you so much. I don't know if I want to be all set, but I'll take it. I guess that means we're done with Bev, at least for a little bit. Don't have to have any more of that for a little bit. Thank you so much for joining us. It has been a great time. Sandy B, thank you. Thank you, guys. Pure jealousy. Trial confirmed my decision to not attend law school. I love it, but don't have the patience. Mad respect to you and all who are fighting the good fight. I get it. I mean, we're a jaded bunch. Practicing lawyers. We can be a real jaded bunch. We very dark humor, right? The kind of dark humor where when people ask you about their advice about going to law school, your answer is don't go to medical school. Like, you still have time. It's not because it isn't an important profession and a valuable profession and a very rewarding profession in many ways. But yes, it can be aggravating. It can be heartbreaking. It can be devastating. It can really just put you face to face with a lot of injustice that you thought in your idealism wasn't going to be there. But there it is around every corner. Yeah. I don't blame you. You still got time to go to med school. If I could go back, I definitely consider the whole forensic pathology route. I could see the dealing with the people that don't talk. I could definitely see the attraction of that. You still have time. Micro Kimmy, would the taxpayers be heard if they don't want a retrial due to the wasteful spending? Could the Commonwealth be saying they're retrying just to save face and then change course once the crowd dies down? Yeah, absolutely. Yes, on both of these. It just depends on the prosecutor's perspective of whether he's in danger or not. Is there enough people? Are they people that are situated in the right places to be a threat to him and his ability to maintain his position and stuff? Are they able to, is there a risk that concern is going to spread? Do they have the ability to amplify their message and potentially cause him problems politically? All of those things, yeah, he can and probably will consider, because prosecutors are first and foremost elected politicians. And then, yes, it could absolutely be a situation where they change their minds down the road. This is not obligating them in any way to go through with it. It just, it's press for today, and we'll get a trial date at some point, and then that's essentially when their deadline is going to be. The pretrial conference for the next hearing will be put up or shut up time, and if they want to go forward, they'll have to confirm the trial. Desert Cat, how do we know jury didn't partially fill out the jury forms and find her not guilty on at least one count? I don't trust Bev. I would assume that the papers, including because remember, part of the instructions is that their notes are collected at the end and destroyed. The jurors do not get to keep their own notes. There's all the copies of the jury instructions that went back into the room with them and stuff. The exhibits went back into the room with them. So there is typically a pretty tight control over those types of materials. And they should be made part of the record because these were the instructions and the verdict forms that were actually given to the jury. So their form as they came back, is part of the court record. So frankly, they should be filed at some point and everybody would be able to see with their own eyes. Of course, that doesn't ever foreclose the possibility that somebody could engage in shady business and swap out the forms or something like that. But, you know, just without proof, it's pretty unlikely. And there are more than likely more than one set of eyes on the materials in that jury room. Even just with the exhibits, for example, we saw there's kind of this allocation of authority between the court reporter and the court clerk. So like there's a lot of hands involved in it. It would be a pretty high risk proposition, you know, for somebody to try to mess with it like that. So the bottom line is that the forms should be filed, and then everybody will be able to see and know for themselves. Sherry Graham, if second trial is a mistrial again, what next? Then they get to decide again. I'm not aware of any restriction of Massachusetts law on the number of times they can retry her. There's really no limit under the Constitution or anything like that. Theoretically, they can retry her into infinity. Legally speaking, the only practical limit is practical. It's just practical considerations. At what point will they decide enough is enough? El Stinko farce. Thank you for all of your coverage of this. Could Karen Reed testifying have swayed the jury? P.S. Go Sox. Boo! You know, I don't know. And we can never know. It's a counterfactual, you know. I will say this. In all of the cases I took to trial, I have never regretted putting a client on the stand, and I have regretted not. That's all I'll say about it. Greta Thunderer, I'm disappointed that a mistrial in this case doesn't prevent Karen from being retried. The prosecution had their chance and they failed. It's unfair to cost this woman thousands more to keep defending. You know, I see the argument that a mistrial should count as the prosecution not meeting its burden of proof. That double jeopardy should attach with a mistrial. You get one bite at the apple. I can see that argument that that's how it should be. It definitely makes some logical sense to me. It's just not what the law is, unfortunately. Doesn't mean it can't change. But that's just the classical distinction between what the law is and what we might want it to be. The cost, the risk, the uncertainty. Still, after all this time, she's still out on release. She's still got her liberty restricted by release conditions. She's still got this, you know, aura of suspicion around her. It's just, yeah, it's very unfortunate. I can definitely see the argument that if they could not convince the jury beyond a reasonable doubt, okay, it's not an acquittal. It's not an acquittal. She didn't get vindication in that way, but they didn't meet their burden. Bottom line, they couldn't convince a unanimous jury. I can see the argument why that should be where jeopardy attaches. Rainman YYC, let this sink in. Out of 12 random people in the county, at least one watched Trooper Paul testify and said, "Yep, I'm in. The Canton brainworm is real." A point I made the other night on just last night on the Broken Bakers stream was that out of all of the kind of surveys and stuff like that that's out there, the ones that I really tend to pay attention to are the ones on Court TV and Law and Crime, because that's just the least, it's the pure source, you know, it's the ones that's least likely to be biased by, I'm watching this channel because I agree with the perspective of the person who's doing the stream. So it just seems most likely to give you a more fair cross section of the people watching the trial. And those are generally coming down 80% not guilty, 90% not guilty. I mean, you know, pretty good numbers. But when you do the math, 80% of 12 doesn't get you an acquittal. It's not enough. So if this jury is representative of the court TV audience, yeah, it's a predictable outcome. And that's, yeah, not even just a single person looked at it and thought, sure. And frankly, you know, I don't think that's what it is. I don't think it's that they looked at Trooper Paul and thought, great, you know, yeah, he seems real smart. He got it all figured out. I don't think even they're that bad. I think it is really based on Karen herself. It's the character assassination strategy. It's very effective with some people. Some people really, really like to judge other people. They really, really like to judge other people, and then they really want to hold them accountable for the perceived failings. There's a lot of people like that out there. And that would be my perspective. I don't know. I'd focus group it. But I think it's the I hit him combined with just the overall smear. People decided they didn't like her. They don't trust her. They're suspicious of her. Therefore, she's probably guilty. Jennifer Clark, if defense theory is true, light did not shatter at the house. Arca built cannon because shatter pattern started with impact from small item. Hammer would be a great follow-up question, wouldn't it? Arca guys, would you mind hitting some taillights with a hammer and seeing what kind of patterns you get? See if it matches what you see with these taillight pieces. Check for like tool marks and things like that on these taillight pieces. That would be helpful if they could follow up on stuff like that. They'll have the time to do it. It's just not clear if they would have the ability to do that with these particular guys, or if they would need to go hire a whole new expert to be able to look at those specific defense questions. Alex Kane, how likely would the defense have put this to a mock jury beforehand? What percentage of time does this happen? Only available to clients with deep pockets. Yeah, this is definitely a deep pocket thing. This is essentially like pretrial focus grouping. Like that's what you're doing. You're giving it a test run so that you can get the feedback from them about what they found persuasive and what they didn't, and then adjust your strategy accordingly. The more money you have, the more times you can run through that to really get your whole strategy refined. I don't know if they did or not. It's not super common. I don't know if Karen is that deep a pocket, you know, to be doing something, because it's a lot of money, you know, especially even though the jury, the defense can put on a mock trial that doesn't take 8 weeks, you know. It's still a lot. It's still a lot to present to them. It's a lot of time. It's a lot of effort. You know, it's costly to do that type of thing, and let alone just the expertise. You're typically paying a consultant, a jury consultant who's got a lot of expertise in being able to set this kind of thing up and analyze it, and know exactly what questions to ask and how to evaluate your performance and stuff like that. So yeah, it gets very expensive. And she's already paid a lot of money. She's paid a lot of money for lawyers. She's paid a lot of money for forensic people. Dr. Sheridan did not come cheap. Dr. Russell, I mean, who knows? Who knows? But at the very least, you're paying for these people to fly out, and it's just, yeah, it can be quite a lot. So I don't know if they would have done a test run. It wouldn't shock me if they did, but it also I think wouldn't shock me if they. These are both very experienced trial attorneys. It wouldn't shock me if they just went ahead and relied on their own expertise and experience. Shy Gal 8, Andrea, can you look at YSL judge is being recused? I saw he recused himself. Like everybody kind of has been saying for weeks, like you need to do. He doesn't have authority to decide his own contempt sanction, his own recusal motion and stuff like that. So I did see that. It's the right call. He's stepping back until some of those issues get resolved. I'm not gonna look like deep into this case, but I did mention before I read that they're gonna release the transcript of the ex parte hearing, so I'm very interested in that. I will certainly be taking a look at that. Brian Alleman, as much as I have enjoyed your coverage, my award for best moment of trial coverage goes to Kurt getting the Chevron news during verdict watch. We should all get to be that happy someday. Kurt was really thrilled. He was having a victory lap after victory lap on Friday. I'm not going to lie, I was shocked. I didn't expect it. I mean, I knew that it was teed up. I knew that they were going to consider it, but I just didn't think they were going to do it. He, I think, he's just been closer to the ground, I think, on a lot of this litigation, following it a lot closer than I have. So I don't think it was quite as shocking to him as it was to me. I wasn't quite sure what to make of it. My first reaction, because the presidential debate was the night before, and my reaction to that debate had been, if this does not convince everybody beyond a doubt that your vote for the person on the stage, it's kind of just it's a charade, because neither of these people are running the government. The man on the stage, who is the current president, he's not running the government. Look at him. Look at him. The government is being run in the shadows. And if this did not make that absolutely crystal clear, I don't know what did. So I was all prepared to be very cynical and be like, oh, the vote, it doesn't even matter. It's the deep state has captured the government, because the administrative deep state is a very, very big part of that. Well, then the very next day, the Supreme Court turns around and like deals this massive blow to the administrative deep state. So I'm like, I gotta really shift my worldview all around with that. But anyway, Kurt did have a wonderful day, and I'm very happy for him. Joe Mendoza, it does look like Morrissey ran unopposed in 2022. Most of the time they do. It's hard to challenge an incumbent. It's hard. They have the name recognition. They have the machinery in place. They have the connections in place. You've got to basically be able to go out and steal their endorsements, steal some of their support. It's a tough call. If they're not already vulnerable, then it's a real uphill battle. So the question is just going to be, will this make him vulnerable enough that becomes a little bit more of a tempting perspective for an outsider. Joe Mendoza, if this was YSL case, Chief Judge Glanville, he would have had a private session with the jury already and coerced them to land on verdict. The audacity. Yeah, he might have. It's just unbelievable. It really is. He's having the ex parte conversation with the witness and the prosecution and the witness's lawyer, and he's keeping the defense out of the room. And I don't know if it got confirmed or if it's just rumors that like they're leaning on the guy, threatening him if he doesn't testify the way they want him to. I don't know. That's why I'm very interested to see this transcript. Very interested to see it, because it could get ugly. It could get very ugly. Steve F. Andrea, you've been a great Sherpa to navigate the issues for us lay people. Watched a few streams, but in the pantheon of law tubers, you are tops. Well, thank you so much. You can call me, oh gosh. So my grandfather went to Everest, went to base camp when he was, I think, 78 years old. My grandpa was an amazing man. He has the world record for being the oldest man to climb Mount Rainier. I believe he was 84 years old the last time he made it to the top. I haven't made it to the top a single time. I've never tried, but it's no joke. No joke. Anyway, he went to base camp at Everest, and he was very popular with the Sherpas who would just assist with the trek and stuff like that. Because of his age, they were very impressed by him and stuff. So they gave him a name, a Sherpa name. And so I learned about the Sherpa naming conventions. The name is the day of the week that you were born, and then your like personal name, like your unique name, and then Sherpa. And so he was Tenzing Bill Sherpa because he was born on, I believe, Tuesday. I was born on Sunday. I don't know what Sunday is in Nepalese, but if somebody can figure that out, you can call me that Andrea Sherpa, and I would consider that a deep honor. Lisa Bug, cost Karen lots of money to do the investigation the DA failed to do. Well, isn't that the truth? Isn't that the truth? Isn't that really what it comes down to? Yeah. Appalling. Appalling. And still so much undone. You know, she can't do it all. She can't do it all. But like all of these mixed profiles, where's the comparisons on those? Yeah, that recreation of the taillight, I still don't have an answer. I would love to know. Was there extra taillight? And if so, how much extra taillight was there? Because I tell you, when I look at all those pieces and like some of them, you know, are like twice the size of my head, don't look right. Really doesn't look right. But I never got an answer. I would love for them to be able to use this time productively to really drill down into those types of details, because that's what's going to tell the story. If that's what happened, those details will tell the story. So I just would love to hear more of that. Melanie Jacobs with a super sticker. Thank you so much, Melanie. Really appreciate it. Well, unsatisfying outcome. No question about that. Not what anybody wanted. I will continue to look on the bright side, because that's just what I try to do. I'm going to look at it as an opportunity for the defense to learn, to continue to dig, and to get evidence. I'm going to look at it as an opportunity for the FBI to continue their investigation, just like everybody had wanted initially. And as much as I regret that Karen is going to have to spend all of this extra money and have all of this hanging over her head for this much longer, since I firmly believe she should have been cleared, she still has the potential for redemption out there. I mean, as hard as we think it is for a jury to convict her of something, it is always a very real possibility. We just you cannot understate how real that possibility is. That a jury will convict for reasons that don't make any sense, on evidence that you would think should be rife with doubt. And especially when they are unable to agree and there is so much pressure on them to just compromise, just convict her of something. So they didn't do that. It is good that the not guilties on the jury, they stuck with their principles. However many of them there were, they stuck with the principles. They didn't allow that to happen. So she still has the opportunity for vindication. I'm going to look at it that way. And in the meantime, July 22nd, we'll get that status hearing. July 22nd, I think we're going to be in the Baldwin trial, aren't we? No, it will just be over. It will just be over, at least in theory. We might be on verdict watch in Baldwin. That case is starting next Tuesday, July the 9th, and it's supposed to run through the 19th. So things could go long, things could go short. We'll see. We'll see where things are at on the 22nd, but I will certainly have it on my calendar. And if there is a good opportunity to be able to pop over and take a look at that, get an idea of what's coming next, we'll go ahead and do that. Otherwise, if you're interested in watching the Baldwin trial, that's what I'm going to be turning my attention to next in the short term. There's been a whole bunch of stuff filed over the last several days, last minute things as they get prepared for trial. So I'm going to be digging through a lot of that. Will probably do my best to get some stuff out on Substack before that next trial starts. It's going to be on Mountain Time, which is only 1 hour ahead of me. So I really look forward to starting at maybe more like 8 a.m. It's going to be great. What a change of pace. So yeah, that's what to look forward to in the short term here, guys. Would love to see you all join me for any of those if those have interest to you. I'll tell you, I'll just go ahead and write out front my my bias on the Baldwin case. I don't have a strong bias against him, for him. I'm certainly going to listen to the evidence, but I will just tell you my kind of instinctive reaction to this type of situation is I am just not convinced that a person can delegate firearm safety to somebody else. Just not sure I accept that that's viable. It's just too important. Firearm safety is too important. But I'm going to listen and see what everybody has to say, see what I can learn from that. So it should be interesting. I think it should be very interesting. Just another situation where he did that Stephanopoulos interview. Boy, was that a bad decision. Very bad decision, because it's going to really limit his options as far as choosing to testify or not testify. But I also have the impression that Mr. Baldwin is maybe not the kind of client who is very controllable. So it could get interesting. Anyway, I'm looking forward to that, and I will be interested to see how all of that unfolds. So, guys, if you come back on the 9th, I'll be here. Be looking forward to getting that one underway. In the meantime, go Phils. Enjoy some time off. Realize this was not a satisfying outcome. But we'll soldier on, because what else are you going to do? That's the choice we have. We're just going to go ahead and continue to keep our eye on it and see what happens next. And we'll keep hoping that everybody in this case can at some point get some closure. So take care, guys. Thank you so much for joining me. Appreciate all of you so much, all of your support. You're jumping on to join me on like zero notice. As soon as I knew the court was coming back into session. I had high hopes that they were going to work it out, but it was not to be. So unfortunate, but onward and upward, and better next time. All right, guys, take care.